may be seated.
Good morning, welcome to Warren County Municipal Court. Today is January the 5th, 2026. I'm Judge Capper. Look around, it's a big docket today, so have some patience. It's going to take a while to get through it. We've got a lot of cases. We're going to start off with the reviews for people who have been ordered to do something, and this is a check to see if you're making progress on that. So when your name's called for review, come up to the table to the right with the group that you're called with. And if you don't get called and thought you should have been, you need to go check in with the clerk. Call the reviews, please.
Jessica Bailey, Kaylee Bennett, Samuel Clark, Brian Kitts, Derek Lockhart, Angela McCollum.
Okay, Jessica Bailey, 2519.
She's here, Your Honor. She wants to get back.
Okay, we'll come back to her. Kaylee Bennett. Kaylee Bennett here. Kaylee Bennett. No. Her cases are 20, 2681, 21, 2280, 2217, 221604. Been called for, has not here today.
Your Honor, I formally represent her. She texted me. She was having trouble getting on Zoom, so that's all I know.
Okay, well, I'll hold it till the end of the docket before I...
And I'll tell her to call the clerk and try to figure that out.
Okay.
She just texted me.
Samuel Clark. Samuel Clark. 20-1242. Samuel Clark is not finished. He did his community service. He's not finished everything in his order. So it'll be a benchmark for failure here today. Brian Kitts, 22-2478. Brian Kitts is here. Community service done. You don't have that much left to do. Looks like, okay, you used to have $120 left on your fees and costs. Are you making a payment today?
I'm gonna go ahead and pay the 120 and finish off.
You gonna pay it off?
Yeah.
Okay, well, here's why I do that, because I've had people tell me that, and then they don't do it.
No, I'm here, I'm going, as soon as I walk out right here, I'm going to the office to pay
I'm
it
not
off.
doubting you, sir, but I have thousands of cases every year, and some people lie to me in open court. Can you believe that?
I wouldn't lie to you. No
So I'm not
problem.
gonna assume you're gonna pay it. I'm gonna give you another date, and then if you paid it, you don't have to come back.
Right there's the 120.
February the 13th. February 13th is your next hearing, but if you paid it off by then, you don't have to be here.
All right.
Go see the clerk. Derek Lockhart, 25-659-660, he's at Southern Hope. Mr. Quan is here from Southern Hope with a report. Meeting all program requirements. And ongoing, so we're not finished, but it sounds like he's making good progress.
Trying to.
Good. About a month out for your next hearing.
I'm gonna try to work some community service off either this Saturday or next Saturday.
Okay, that's good. All right, February the 9th is your next hearing. That'll be a Monday. 9 a.m. Okay.
Thank
Good
you.
progress. Keep it up.
Thank you, Kevin.
You're welcome. Angela McCollum. Yeah, restoring hope.
Yes, sir.
Doing well. Following rules. Screens are good. Good job.
Thank you, sir.
Okay, is she able to start doing some community service now?
Yes,
Okay,
she is.
you got 5 days of that, and you can't pay, which right now you probably can't because you don't have a job, right? You can do extra towards your fines and costs, you get credit toward your fines and costs if you do extra. You got 5 days to do if you're ordered to do. Okay, I'll set you the same day of February 9th. This is your next hearing. Okay, good job, keep it up.
Thank you, sir.
9 a.m., February the 9th. Jessica Bailey, 2519 is here. She's also at Southern Hope. Following rules, continuing treatment, and it's like the screens are good. Okay, you've got a lot of community service to do. You got 56 hours more to do.
I do plan on doing most of that before I see you again.
Okay.
And then I'm working now, so I'll be paying on my fines and costs.
Can you pay anything today?
I can't, because I haven't got my, yeah.
Okay,
Your Honor, if I may, I have a report. Ms. Bailey was ordered on November 24th to be here on December 2nd, and she was not here at that time.
I wasn't here only because it was the day that it snowed and stuff, and then transportation wasn't available in the morning, so, because the roads were bad. That was the only reason I didn't make it.
aren't you at Southern Hope?
Yeah.
I mean, that's not that far away. You
Well,
can
I mean,
walk it.
yeah, I understand.
Okay, well, let's get a commitment as to when you are going to be here for community service. Give me a date when you're going to be here.
I get my schedule today, so I don't, let's see, I don't,
Your work schedule?
Yeah.
Where are you working?
RRS.
Okay. Well, here's what I'm going to suggest. You tell them that you got to be here next Saturday.
Okay.
Okay? I think they'll work with us on that.
Yeah, I'm pretty transparent with her, so,
Okay, so that's, you're going to be here the 10th,
okay,
7:30.
all right.
Let's put it down. February the 9th, next hearing, 9 o'clock.
February 9th?
Yes, ma'am.
Thank you, Ron.
Thank you.
David Moore, Judith Naker, Christopher Roadcat, Mason Sly.
David Moore is 25-135. And your David.
Yes, sir.
Okay. And you're at RRS,
Yes, sir.
outpatient.
No, I'm an inpatient.
You're inpatient now?
Yes, sir.
Okay. Okay, we had all, that's a good report, good screen, so good job on that. What's going on? Are you starting to work, looking for work? What's
I'm
going on?
looking for work right now.
Okay.
So I've been making phone calls each week and trying to get interviews. Where it's been the end of the year, it's been kind of iffy right now, so I'm hoping to make something happen within the next week, so.
Okay, you able to do pretty hard physical labor
Yeah,
outside?
yeah.
Okay, do you have the number for Superior Marine? I know they'll hire people in recovery, and
Okay.
it's pretty good pay, but it's hard work. You're gonna be outside in the winter and in the summer too. It's hot in the summer and cold in the winter, but it's not $10 an hour.
Yeah.
Double that. So, we've got some connections there, and
Okay.
they're always looking for people. And if you work hard and they're always looking for welders, and they'll train you to be a welder, and you'll make a lot more money. if you
Yeah.
wanna
I
become
mean,
a
that sounds
welder.
great. I mean, I can write down the number.
I'll get him the number you want.
Mr. Cooper will get it. to
Okay.
you.
I talked to Mr. Cooper also. I am working on my community service at Facing Hunger.
Okay,
So I just got to get the proof of that, what work I have done already, so.
all right, February the 9th will be your next hearing, 9 o'clock. Judith Napier, 22-27-47. Southern Hope. And your meeting requirements and your screens are good, so.
If I may, Your Honor, she's made significant progress just in her attitude and her pursuit of sobriety and the actions that she's taken behind it. Very proud of her.
Okay, very good, thanks for that report. And she'll need to start working on some of her community service too.
Yeah, I've got 5 hours. I've had 2 surgeries. I'm not making excuses. It's just like I was in the hospital last weekend and I had to have another stent, have a kidney shutting down. So like, I've been in and out of the hospital a lot, but I am planning on going back and getting more.
Okay. All right, February 9th will be your next hearing, 9 o'clock.
Okay.
Thank you.
Good job, keep it up.
Thank you.
Christopher Roadcat is 23,646, he is here. And also he has 21,1172. You did make a payment, no, that was last year. You got a payment today.
No, sir. I will try to do some more community service Saturday.
Yeah, you did community service since the last hearing. Okay. I'm going to set you for February the 6th.
Can we set it for a different day? My fiance goes for surgery on the 6th.
Okay, February 2nd.
Okay.
February 2nd, that's a Monday, 9 o'clock. 2/2/26, 9 o'clock. Mason Slot, 25,484. It's at RRFs. Got a report from them. Just started, really. Good screens and compliant.
Arraignment. Anybody that has an arraignment?
Okay, he needs to start working on his community service too.
I just did some at Facing Hunger with David, but we didn't have our papers for the
Okay.
proof of it.
Get
Yeah.
him and turn him into either Mr. Cooper or Mr. Major.
Okay.
February 9th will be the next hearing. 9 o'clock. Okay. Good job. Shania Westmoreland, 18,228. Shania Westmoreland. All right, you're Shania Westmoreland.
Yes, sir.
Okay. You did make a payment December the 1st, you have a payment today.
Yeah,
How much are you paying?
$30.
Okay, you got community service left to do too, 4 days.
Yeah, I'm gonna try to get some done this month.
Well, give me a date, let's get a commitment. This is a really old case, so I need a commitment.
Well, let's
as to the day
do
you're gonna-
Thursday and Saturday.
You're gonna be here when?
Thursday and Saturday.
Thursday and Saturdays, okay, that's the 8th and the 10th. Okay, Mr. Cooper's got you down for that. Go see the clerk and make your payment. Next hearing, February 9th,
All right.
9 o'clock. That finishes the reviews, we're gonna start arraignments now. Arraignments are what lawyers call the first hearing on a case. Or if you got a warrant, we're gonna call you with the arraignments even though it's not your first hearing. So when your name is called, come up to the table to your right, stand there, I'm gonna tell you what the charges are. You have a right to remain silent, you don't have to say anything, but if you do make statements, everything in this courtroom now is being videoed, so, that's the question. So, there's a video of you saying what you're gonna say, so if you get up and say a bunch of stuff that helps the prosecutor, he can play that back against you later. You have a right to have an attorney, to have one appointed if you can't afford one. And if you want to talk to someone, you should talk to a lawyer, because what you tell a lawyer is privilege. It can't be used against you, but what you say in open court can be used against you. You have a right to have bail and to make the state of Ohio prove any charge against you beyond a reasonable doubt. If you enter guilty or no contest as a plea, you're waiving those rights I just told you about. You shouldn't waive your rights if you don't understand the proceedings, if you're confused, if you don't know what to do, or if you want a trial, or you want a lawyer. Any of those reasons, you should enter not guilty when you're asked for a plea. Call the first case.
State of Ohio versus Joshua Saunders, case number CRB 25-812, A, B, and C, CRB 2606, A and B. State of Ohio versus Nathaniel Ellis, case number CRB 25-814, A, B, C, D, E, and F, CRB 265, A and B. State of Ohio versus Samuel McLeese, case number CRB 25-813, A, B, C, and D, CRB 264.
Are you saying in the police?
Okay, so from my left to right, we've got Joshua Saunders, correct?
Yep.
And in the middle, Nathaniel Ellis,
Yep.
and then Samuel McLeese.
Yes, Your Honor.
Okay, so I'm going to start with Mr. Saunders, and these may all be the same, I'm not sure, I haven't looked at it. All right, so for Mr. Saunders, case numbers CRB 25812, A, B, and C. The A case, 25812A, alleges that on December the 6th of 2025 in Mason Township, you did shoot at, kill, or take an animal, that being a deer, from a motor-driven conveyance, being a Chevrolet truck. So that is a 4th-degree misdemeanor, violation of Revised Code 153102, maximum penalty is 30 days in jail, $250 fine. 2512B alleges that December 6, 2025, Mason Township, you did possess a deer, parts of a deer that were taken illegally by jacklighting. That's a 3rd-degree misdemeanor, maximum penalty is 60 days in jail, $500 fine. A12C case number alleges December the 6th in Mason Township, you did cast rays an artificial light to the field in order to locate a animal, being a deer, and having in your possession a hunting device, a rifle. That's jacklighting. It's a 3rd-degree misdemeanor. Maximum penalty is 60 days in jail, $500 fine. And there's other case number is 266 A and B. That alleges that on December the 7th, 2025, in Mason Township, while under the influence of alcohol or drugs of abuse, to carry a firearm or dangerous ordinance, and to charge there is using a weapon while intoxicated. 1st-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. 26B alleges that December 7th, 2025, without the right to do so, you did purposely prevent, obstruct, or delay a public official in the performance of their authorized acts or duties. That's obstructing official business. It's a 2nd-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand those charges?
Yes, Your Honor.
Do you understand the rights you have as a defendant?
Yes, Your Honor.
How do you wish to plead to these charges?
Guilty.
If you enter a guilty plea, you're admitting the charges are true and you're waiving your rights to have a trial and a lawyer. Do you understand that?
Can I plead no contest?
You can plead no contest. It really probably is not going to make much difference in the ultimate outcome. No contest just means I'm not admitting that I did what's alleged against me, but I'm not denying it either, and I'm agreeing that I can be found guilty without a trial and without a lawyer if the court believes the state has sufficient evidence to convict you. So 99% of the time, it results in a guilty finding. Mr. Eel.
If I may, Your Honor, I have the enforcement officer, Mr. Abbott, here, and he had extensive conversations with these young fellas before today as he investigated and charged them. And he has written out for me what he would ask me to recommend as far as sanctions, if they want to hear what we would offer, and maybe that would influence their decisions.
Okay, go ahead and tell the court and the defendants what is going to be recommended by the state.
Well, Mr. Joshua Saunders, that's the one that you just read his charges, correct?
Correct.
We would be asking for a total fine of $1,000, restitution of $250 to the Division of Wildlife for an antlerless deer, $100 restitution for processing payable to Tim Saunders, owner of the deer processing shop, revocation of hunting privileges for 2 years, and probation for 2 years, and suspended jail term of 10 days with a community service order as the court would determine.
Okay, so you've listened to that, Mr. Saunders. You have a right to have an attorney, and you have a right to consult one. You don't have to enter a guilty plea or a no contest plea today. And if you're not sure what to do, if you heard what I said when I was explaining the rights of defendants, you should enter a not guilty plea. So it's up to you. It's totally your choice to make today. After you've heard what the state's going to recommend, how do you want to proceed?
If I plead guilty, then I'm accepting like what they just offered, right?
Your group, yes, I would say so. Now, here's the other thing you need to understand. That's their recommendation. I don't have to do what they recommend.
Right.
They just make a recommendation to the court. They don't control what the court does in sentencing, but they make a recommendation based on what they think the evidence is. So, if you're not sure what to do, I would recommend a not guilty plea.
Yeah, I'm not sure what.
Okay, I'm going to enter a not guilty plea for you then. Do you want to be considered for a court-appointed lawyer, or do you want to hire your own lawyer?
Court appointed.
Are you working?
Yeah.
You have a job?
Yeah.
What do you do? Because I can't appoint, if you can afford a lawyer, I can't appoint one for you. You can only get a lawyer appointed if you're what's called indigent, which means you meet certain guidelines financially for a court-appointed lawyer.
My brother-in-law owns Impeccable Property Management, and I work for him.
Are you paid by the hour or a salary? How do you get paid?
I usually just get paid by the week, honestly. It just depends.
Okay, I have to determine your gross annual income. That's what our Supreme Court tells me I have to do. Do you file an income tax return? Well, should you be filing an income tax return? If you did, what would you show as your gross annual income?
Honestly, I'm not. I just have to look at it.
What do you make in a week?
About 600. But we're not like, it's determined on the weather too, so we don't work.
It's seasonal work?
Yeah.
Okay. So if you're making, and that's your take home, you're taking home 600?
Yeah.
But they're not withholding any taxes?
Right.
Okay. So that's $30,000 a year, roughly. Do you have any dependents? You don't have any children you're supporting or anyone else you're supporting?
No, Your Honor.
I'm not going to appoint a lawyer for you because I think you have enough assets if you're making that kind of money that you can hire your own lawyer.
Yes, Your Honor.
I'll give you time to do that. We'll come back to your bond and setting another hearing date after I hear from the other defendants. We don't set you all at the same time. You can all come back at the same time. All right, Nathaniel Ellis. That's you, sir.
Yes, sir.
So we'll start with your charges, 25814A. Okay, that alleges that December the 7th, 2025, in Mason Township, you did shoot a wild animal, being a deer, from across a public roadway. That is a 4th degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. The B case alleges that you took more than one deer during deer season, so that was over limit by one, and that's a 3rd degree misdemeanor. Maximum penalty is 60 days in jail, $500 fine. The C case alleges December 7th in Mason Township, you possessed a deer parts that were taken illegally. That's a 3rd degree misdemeanor. Maximum penalty 60 days in jail, $500 fine. The D case alleges December 7th in Mason Township, you did shoot at or kill a deer by means of a motor-driven conveyance, being a truck. That's a fourth-degree misdemeanor, maximum penalty is 30 days in jail, $250 fine. The E case alleges December 7th, Mason Township, you did cast the rays of artificial light to a field in order to locate an animal for hunting. That's a jacklighting charge. It's a third-degree misdemeanor, maximum penalty 60 days in jail, $500 fine. The F case alleges December 6th, Mason Township, you possessed deer parts without a valid tag. That's a third-degree misdemeanor, maximum penalty 60 days in jail, $500 fine. So those are all the charges under 25-814. Then you've got two charges under 26-5 case number. And that is the A case alleged that on December the 7th, 2025, Mason Township, while being under the influence of alcohol or drugs, you were carrying or using a firearm. That's using a weapon while intoxicated, first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. The B case alleges, same time and place, that without the right to do so, you purposely prevented, obstructed, or delayed a public official in the performance of their duties. That's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand these charges?
Yes, sir.
How do you plead to the charges?
No contest.
Okay, no contest. I explained it to Mr. Saunders. I want to make sure you understand it. Really, the only time it makes a difference is if you're in a car wreck and you hurt somebody, if you enter a guilty plea to the traffic charges, that guilty plea can be used against you later in a civil case because it's a complete admission that you did what's alleged. No contest is really only important in that kind of circumstance because it's not an admission. I don't think you're going to get sued civilly over this, but I just want to make sure you understand what it means. When you enter a no contest plea, you're just telling the court, I don't admit that I did it, but I'm not denying it either, and I'm agreeing that I can be found guilty without a trial, without a lawyer. But it can't be used against you in any civil proceeding. There's unlikely to be any civil proceeding here. It's likely going to wind up with you being found guilty. Do you understand that?
Yes, sir.
Okay. Is that what you want to do?
I plead guilty.
Okay. What's the state's recommendation for Mr. Ellis?
Your Honor, the recommendation is a fine of $1,000.
Is it the same as?
No, because the charges are a little bit different.
Okay, go ahead.
Restitution of $1,500 to the Division of Wildlife, minimum values for 2 antlered deer and 2 antlerless deer taken or possessed illegally. That's what that $1,500 is for.
Okay.
And restitution to Tim Saunders, the owner of the deer processing shop, and that's $300. And that's all.
I'm a little confused on that. Why would were the deer processed or what? They were processed later?
Yeah, the state took possession of them. And then
who's that paid to?
Tim Saunders.
Saunders. So is he owed that money or did the state pay it and it's going to be reimbursed to the state?
He's owed, Your Honor.
He's owed?
Yes,
Okay.
sir.
We also want hunting privileges revoked for 2 years and probation of 2 years with 10 days in jail suspended and community service.
Okay, so Mr. Ellis, you've heard what the state's recommending. You have a right to make a statement to the court, and you can comment on what they're recommending if you want, or you can make an explanation about what's alleged to have happened. It's up to you. You can make a statement to the court and as to anything you think is important for me to know about this case. Do you have anything you want to tell me about this?
No, sir.
Okay. All right, so I'm going to go ahead and I'll send you as the state's recommended. So let's do the judgment entry on that. So we'll start. We can put it on the A case. Start with the A case. We'll have to split it up because I think it's a 4th degree misdemeanor. Okay, so I'm talking to myself, but there are certain limits on the fines. And they're asking for a total of $1,000, so we'll have to put these together. So the max on this is $250, so it's a $250 fine. Or you pay the court costs, 10 days in jail, all suspended. I'll have a review hearing on July 27th of this coming year. That's when, if you were here earlier, those were the review hearings for people who have stuff ordered to do. If you get everything done before then, you don't have to come to that hearing. If you don't have it done, then you'll have to show up. If you don't show up, you'll get a warrant if you're not showing up, or you can go to jail if you don't make an effort to try to get your stuff done that you're ordered to do. Okay, so jail suspended, I'll give you 5 days community service, 2 years of probation, restitution to the state of $1,500, and to Tim Saunders, is there any relation? Tim Saunders, beer processor, for $300. But you'll make those payments to the court, and we'll see that it goes to where it needs to go. Hunting license is revoked for 2 years. You'll be on probation for 2 years. And I think that's everything on that case.
Your Honor,
Yes.
if I may, with respect to his cases, I just need a court order also on the evidence that was seized for it to be forfeited to the state.
Okay. So all evidence taken by the state, which includes the deer parts, would be forfeited to the state.
We also have a .22 rifle and some ammunition as well.
Okay, I'll order that forfeited and destroyed. The deer, is that donated, or what's usually done with that?
Right, so any meat that was salvaged will be taken to City Mission in Ironton.
Okay. All right, the deer can be forfeited and donated for charitable purposes. Weapon I'll order destroyed.
Oh, Your Honor, the state does use .22 rifles, if they could be.
That's always been my policy. I order them destroyed. I don't want it to come back later and get used in some situation that's traced back to me. So
No, understand.
I'm ordering it destroyed.
Understand.
Okay, so we can go to the B. Okay, the B case is hunting in close season. That's a third-degree misdemeanor. So I'll put a $500 fine on that, so that gets us up to $750. No court cost because it was assessed on the other case. 10 days suspended. You don't have to put all the other things on there because we already put them in the A case. Just put the review hearing in July 27th at 9 a.m. Okay, so on the C case, I'll impose $250 fine. So that gets us up to the 1,000. And that's all we really need on that one. On the D, E, and F, you can just show convictions. I won't impose any penalty on those. I won't impose at all what was recommended for convictions. 26.5, which is the using weapon in the wrong pocket. So I'm going to deviate a little bit from what the state recommended on this. But I consider this a more serious offense. I'm going to impose a $300 fine, but I'll suspend it as long as there's no further violations, no court costs. And I'm going to make it a 60-day jail sentence, which I'll suspend totally. But I've got it there. If you have another violation of any type during your probationary period, I can impose this as well, 60 days additional jail time. So 2 years of level 5 probation, same duty hearing date. And on the obstructing, you can just show a conviction. We don't need any jail time. I've got enough on the other cases. So, Mr. Ellis, you're going to meet, your probation officer is going to be Mr. Major. You're going to meet with him today. You can go ahead and leave the courtroom. He's going to go over your judgment entries with you. He's the contact person with the court. When you go out in the lobby, go to the west side of the building, to your left, that open counter is probation. He's going to go over these entries with you. And as I said, he's your contact person. You've got community service you need to get taken care of. You can do community service here at the court any day, but Sunday or a holiday at 7:30 a.m. Just report to the west side of the building to do community service. Do you have any questions of me?
No, sir.
Okay, go ahead and go with Mr. Mayor. All right, Samuel McLeese, 25-813 A through D. Okay, the A case alleges that on December the 6th, Mason Township, you possessed deer parts that were taken illegally. That's a third-degree misdemeanor, maximum penalty 60 days in jail, $500 fine. B case alleges, now this one says December 6th. I think some of the others said December 7th. December the 6th, 25, maybe they are different dates. Mason Township, you were casting rays of artificial light to a field in order to take an animal. That's a jacklighting charge, third-degree misdemeanor, maximum penalty 60 days in jail, $500 fine. The C case alleges, this says December the 6th, that you did aid another in the commission of a wildlife violation. That's alleged to be Joshua Saunders. Aided him in the use of a motor vehicle and hunting. That's a third-degree misdemeanor, maximum penalty 60 days in jail, $500 fine. The D case alleges December 7th. December 7th, Mason Township, you did aid Nathaniel Ellis in the commission of a wildlife violation, that being jacklighting deer. Third-degree misdemeanor, maximum penalty 60 days in jail, $500 fine. Do you understand the charges?
Yes, Your Honor.
And then we've got one other charge with a 26 case number, so let's go over that. 26-4. That alleges December 7th, Mason Township, without the right to do so, you purposely prevented, obstructed, or delayed a public official in the performance of their authorized duties. That's a second-degree misdemeanor, maximum penalty is 90 days in jail, $750 fine. Do you understand these charges?
Yes, Your Honor.
And how do you plead?
Plead guilty.
To all the charges?
Yes, Your Honor.
Okay, so what's recommended by the state for Mr. Williams?
Your Honor, the state would recommend a total fine of $1,000 a restitution of $500 to the Division of Wildlife, which is the minimum value for an antlered deer, a revocation of hunting privileges for 2 years, probation for 2 years with 10 days in jail suspended, and community service. Also, is that all? Is there a weapon or anything?
No.
Okay. And that's everything on that one.
Okay, Mr. McLeese, you have the right to make a statement if you want. Do you have anything you want to say to the board about this incident?
No, Your Honor.
Okay. All right, so let's start with the 813A. And that was a third-degree misdemeanor, so I'll impose a $500 fine on it. Court costs will go on this case, $125. 10 days in jail suspended. 2 years of level 5 probation. 30 hours community service, that's 5 days of community service, which you can do here any day but Sunday or holiday. $500 of restitution to ODNR. Review hearing is going to be July 27th, which you have to appear for if you're not finished with what you were ordered to do. 2 years hunting license suspension. I think that's everything on the A case. The B case is also a third-degree misdemeanor, so I'll impose a $500 fine on that, so that gets us to $1,000 that was recommended. No court costs. And that's all we need on that. We've got the other requirements on the A case. On the C and D, we just show conviction, no fines or court costs. I'm just reading the affidavit. Okay, based on what I've seen in the affidavit, I'll just show the conviction on the obstructing. I'm not going to add any additional jail time. 10 days will be sufficient. Suspended.
Court costs, Your Honor?
No. I won't impose court costs. It all grows out the same incident.
Okay.
On that one. It should be on the VA case. Okay, so Mr. McLeese, same thing for you. You go check in with the probation officer, Mr. Major, and then after you've done that, you're free to go.
Thank you.
All right, so Mr. Saunders, we're back to you. We just need to set a date for you to come back.
Yes, Your Honor.
How much time do you think you need to get home?
Can you give
Let me
me,
give you dates, because it's going to be a while before we come back anyway, so let's see where we are. It would be January the 12th at the earliest, or after, before we would come back for another hearing.
that's fine, Your Honor.
Okay, I'll set it for January the 12th as your next hearing. It'll be a pre-trial. So that's a week, that's only a week from today. I'll put down she will hire an attorney. If you won't discover you need more time, you need to come back and ask for it. Just don't not show up. There's bad stuff starts happening. You do that. I'm going to let you sign a signature bond. $1,500. So what that means is you're just going to sign a piece of paper that says, I promise to come to court as a lawyer, or I'll get a warrant and have to pay $1,500 for the penalty. And you will need to go to jail to get your fingerprints. So Mr. Cooper's going to give you a form to take to the jail to get fingerprints. Any questions?
No, Your Honor.
Okay, just wait on him out in the lobby. We're going to need the form.
Thank you.
You're welcome.
Appreciate it.
I think it was a day. What about well, does she have protection?
State of Ohio versus Tanner Collins, case number TRC 2612, A, B, and C.
Are you Tanner Collins?
Yes, Your Honor.
Collins, the state's alleging that on December the 30th at 4:33 a.m. in Union Township, you were driving a vehicle while being under the influence of alcohol or drugs or a combination of those things. It's alleged if you get convicted, this will be your first conviction. So that impacts what the possible penalties are. On a first offense, the maximum you face is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can impose on this charge if you're found guilty. There is a minimum, so the least you can get if you're found guilty is 3 days in a treatment program, $375 fine, and a 6-month license suspension. The state's also alleging that you submitted to a urine screen. So urine screens are packaged, sent to a lab in Columbus for testing, and it takes several weeks to get the results. So I don't have any results today to tell you what the state's going to allege was in your urine. We should get that in the future. The state's also alleging that you were driving without a driver's license. That's an unclassified misdemeanor, carries a maximum penalty of 500 hours of community service and a $1,000 fine. There's no jail time on it. And then the last charge is speeding. State's alleging you're driving 87 miles an hour in a 55 zone. That's a minor misdemeanor, maximum penalty is $150 fine. Do you understand the 3 charges?
Yes, Your Honor.
And were you here when I explained the rights that defendants have?
Yes, sir.
Do you understand that? Do you have any questions?
No, sir.
How do you wish to plead to these charges?
Guilty.
Guilty means you're admitting they're true. And here's the other thing. I don't know what, you may have well, obviously you have a better idea than I do is what's going to be in your urine screen. I have no idea what's going to be in your urine screen. You have a right to wait and see what's in your urine screen. Do you understand that? You're giving up. You're saying, I agree with the state. By entering a guilty plea, you're saying, I admit I was under the influence while I was driving. That's what they've charged you with. And we're not waiting to see what the screen results show. You're admitting that. You don't have to do that. You can wait and see what the results are. You have a right to make them prove that you were under the influence. Do you understand that?
Yes, sir.
And if you enter a guilty plea, you're waiving your right to make them prove the charge?
Yes, sir.
Do you want do that, or do you want to see what the results are?
I just plead guilty.
Okay, so you don't want to see what, you don't want to see what the results are, okay? Mr. Heel?
Your Honor, if it please the court, this was an arrest by Trooper Sullivan. And does the court want me to read the?
Yeah, I think to get an understanding of the circumstances, I'm going to have Mr. Heel read the report. The officer makes a report to the court, and he can read that into the record. And then if you have any statement you want to make, you can after you hear what they say.
Yes, sir.
On December 30th, 2025, I was stationary patrol on State Route 7 near milepost 5 in a clearly marked Ohio State Highway Patrol cruiser. When I observed a vehicle traveling above the posted speed limit traveling eastbound, I confirmed the speed using my in-car radar, which read the speed was 87 in a 55-mile-an-hour zone. I made contact with the driver, who stated he was 18 years old and never had a driver's license. He identified as Tanner Collins. Mr. Collins stated they were leaving from a party. I immediately smelled the strong odor of an alcoholic beverage emitting from the vehicle and observed Mr. Collins' eyes to be heavily bloodshot and watery. I asked Mr. Collins out of the vehicle to separate him from the odor, to pinpoint where the odor was coming from, and he agreed. Once Mr. Collins stepped out of the vehicle and spoke with me by my patrol car, I could smell the strong odor of an alcoholic beverage emitting from his breath. Mr. Collins was advised to perform standardized field sobriety tests, and he agreed. I placed Mr. Collins, and this is the horizontal gaze and status test. I placed Mr. Collins into the position and asked for pre-test questions to better understand his ability to perform the test. I asked if he had any questions, and he stated that he does not. I asked if he understood the test, and he stated that he did. Once Mr. Collins focused on the stimulus, Mr. Collins was swaying heavily back to front. I observed the following clue of impairment for HGN: lack of smooth pursuit, distinct and sustained nystagmus, and maximum deviation in each eye. The walk and turn test, based on Mr. Collins' signs of impairment and the weather, I decided not to perform these tests. And the one-leg stand, based on Mr. Collins' signs of impairment and the weather, I decided not to perform these tests. Mr. Collins was given the option to blow into a PBT, and he agreed prior to his arrest. Mr. Collins blew a .094. Mr. Collins was read the BMV 2255 and witnessed by Trooper Bean. Mr. Collins was transported to the Ironton Post for urine. Mr. Collins did provide a urine sample, which was sent to the Ohio Highway Patrol Crime Lab. Mr. Collins was charged with OVI under 451119A1A, speed at 87 over 55, driving without a valid license. Mr. Collins was voluntarily submitted himself to a rehab center in South Point after the arrest. Mr. Collins advised me that he'd been drinking since he was 11 years old and shows signs of alcohol dependence.
Okay. Where are you going to treatment?
He dropped me off at OVI. I ended up leaving the next day.
Okay. Well, here's one thing I think I want to do, because you're so young and they ordered a urine. So I'm going to do, we have capability to do instant ones here. So I'm going to order you to go to probation and get a urine screen. I want to see what's in your urine today. And then after I get the results, we'll come back in here and we'll decide what we're going to do on sentencing. So out to the lobby, make a 90-degree turn to that open counter on the west side of the building. Tell them you need a urine screen, they'll do it. We'll come back in here later, and I'll send you after I see what's in your urine.
Yes, sir.
Okay. Don't leave the building.
State of Ohio versus Alexander Carey, case number CRB 21866.
Judge Mathro.
Yes. So are you Alexander Curry?
Yes, Your Honor.
I didn't get that. Can you try again?
turn your phone off, please. All right, Mr. Curry, looks like you had a pretrial in 22, January 7th of 2022, that you didn't appear for, and a warrant's been outstanding since then. And Mr. Morford was your attorney. Mr. Morford, see you right behind you. So what I'm going to do, I'm going to let you speak with your lawyer, Mr. Morford, and then when you all have discussed the case, come back and we'll decide how we're going to go forward.
Please.
He won't have his file, so you can use the court's file. The case will be recalled, just let the bailiff know.
Thank you.
You're welcome.
State of Ohio versus Ryder, Kenneth Swan, case number TRC 2632.
And it's Ryder Swan, is that your name?
Yes.
Ms. Swan, it's alleged that on January the 4th of this year, 3:17 a.m., Perry Township, you were operating a vehicle while you were under the influence of alcohol or drugs, and the state's alleged you submitted to a urine screen. And also that this, if you got convicted on this case, would be your first time you've ever been convicted of this charge. So on a first offense, the maximum is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most that can happen. The least that can happen if you're found guilty is 3 days in treatment program, $375 fine, 6-month license suspension. That's the minimum penalty. And this is the only charge you have, is operating a vehicle intoxicated. Do you understand the charge?
Yes.
Do you understand the rights you have as a defendant?
Yes.
What plea do you wish to enter?
Not guilty.
Do you want a court-appointed lawyer, or do you want to hire your own lawyer?
I would like a court appointed.
Okay, are you working?
Yes.
What do you do?
I'm a server.
Are you paid by the hour plus tip?
Yes.
I have to determine your gross annual income, so you're going to have to help me out here. Do you file an income tax return?
I do.
Do you know what you showed as your gross income?
Yeah, I'm wanting to say it's around 30.
Do you have children?
Yeah, I do. I have two kids.
Okay, you're eligible for court-appointed counsel then. I'll appoint Mr. Steyer to represent you. She can sign a signature bond. She will have to go to the jail to get fingerprinted. But she can sign a $1,000 signature bond. That means you're promising to come to court. As long as you do, you don't have to pay the $1,000, but if you don't show up, you'll be ordered to pay the $1,000, and that's not the worst part. The worst part is you get a warrant for not showing up. So just come to court, and you won't have to pay any money. She has a urine screen.
I didn't hear what kind of test there was, so.
So we'll have to go out 9 weeks probably. So that takes us into the first week of March.
Your Honor, let me, can I take a look at the file, speak to her, and maybe come back?
Sure.
On this one? Actually, I guess we can go ahead and set a date, and I'll recall it if we need to. That might be better than just leaving us in limbo. Does Friday or Monday work matter to you?
I'm off on Monday. I can't find it.
Okay, I have jury trials on the 23rd of February, the 9th of March I'm available, and the 2nd of March, so I was gonna say if we could, but the 9th, I saw something was on there, but it's a birthday, so it's not an issue that actually stops me from being here.
March the 9th is fine.
Okay.
March 9th is the next hearing, the pre-trial at 10 o'clock, and then if you decide after you talk with her you want to recall for some reason, you can have tell the bailiff.
All right, thank you.
Just quick.
State of Ohio versus Brandon Helton, case number CRB 2318, CRB 2135, A and B, CRB 213053, A and B.
And sir, you're Brandon Helton?
Yes, Your Honor.
Okay, it looks like you missed the hearing recently. It's December 22nd, you had a review hearing
Yes, Your
on
Honor.
these cases, and did you miss that hearing?
Yes, Your Honor.
Do you have an explanation for missing?
I just got caught up in the holidays and I was sick for a while, which isn't an excuse, that's just a reason.
Okay. Well, let's look, we've got 21, 30, 53, and there's, actually that one maybe, it looks like it's finished. 21, 35, 85, you still owe some on fines and costs. 23, 18, you still owe community service and fines and costs.
Yeah, I'm gonna be here Saturday to do today.
Okay.
And I've done a couple days, but I guess it hasn't went towards my hours, it has been going towards my oldest fines. That's what Majors told me.
There was one day on the 21, 30, 53 that got attributed to fines. That's the only one day I'm showing went toward fines. So if you think you've got other days, you need to discuss it with Mr. Major.
Okay.
Your Honor, where he's on for arraignment, his file may not be updated.
Okay,
If
so you could have some credit that's not showing up yet.
Possibly.
Okay.
But I plan on being here Saturday, and then I paid $25 before I came in.
Okay. You paid today,
Yes.
online,
No, I paid
at the
that.
court?
Yeah.
Okay.
Did he say he'd be here this Saturday?
Yes.
All right, I'll set your next hearing for February the 2nd. February 2nd, be your next review hearing at 9 o'clock.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio recalls Alexander Carey, case number CRB 21866. Okay, I have a report from probation officer. It appears to be legitimate that Mr. Carey's been involved with their drug court and has successfully been involved and is due to graduate next month from the drug court. So that's good. I encourage that. You still have to take care of this issue too, so, but I'll consider that certainly in how this is handled. How do you want to go forward with it?
Judge, I'd like to have an opportunity to serve discovery.
Okay. So we'll come back for a pretrial.
Yes, I'm pretty much clear through March, Your Honor.
And Mr. Carey, I assume you're living in Medina County or somewhere close by?
Yes, Your Honor. I just took a 4-hour trip out here last night.
You can appear by teleconference at the next hearing.
Yes, Your Honor.
You can get that link through the probation office. And as long as you're being compliant, I'll let you appear by teleconference. We have other people waiting to get that. So I'm not setting any hearings until at least next Monday, and perhaps we can go further than that out. How about the 26th of January, Mr. Morgan?
That's fine, Judge. Give us time to serve discovery and.
That's 3 weeks from today. January 26th will be the next hearing. It'll be a pretrial at 10 o'clock, and Mr. Carey may appear by teleconference.
Has he had a bond set, Judge?
Yes.
Originally, I believe he did.
An OR bond, so that'll remain in effect.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Tommy Scarberry, case number CRB 25793, CRB 25794. Runs a little bit out of order, but I understand there's some.
All right, I need Mr. Steyer in the courtroom. Mr. Steyer.
I understand you guys have some CDB, but see where they're going on this. Let her talk. Can you sign this one real quick? Right here. Hang on just a second. Data protection.
So how, do we have a recommendation of how we're going to go forward?
I believe the state may have a motion, Your Honor.
Your Honor, I've just been informed that Mr. Scarberry and Ms. Long have a child together who's passed away. And just, I guess, very recently. Because of that, Ms. Long is asking that we dismiss the charges. I think these are extenuating circumstances that probably require us to do something we wouldn't normally do because these charges are very serious. I don't believe that Ms. Long wants a protection order anymore anyway. So what we would do under the circumstances is nolly these with the right to refile.
And the defense has no objection to that, Your Honor.
All right, apology and sympathies for your loss. So what this means is the state's dismissing it, but they're dismissing it in a way that they have a right to refile it if something else happens that they think it makes it appropriate for them to refile. So we would say dismiss without prejudice. So case is knowledge.
Thank you, Your Honor.
You're welcome.
Does she have?
I'm going with Charlotte.
State of Ohio versus Patricia Cook, case number CRB 267.
This is an arraignment. Your name, you are Patricia L. Cook.
Yes.
Ms. Cook, the state's alleging that on December 29th in Fayette Township, you purposely tried to deprive Walmart of property or services without their consent. That's a first-degree misdemeanor theft offense. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Will hereby explain the rights of defendants? Do you understand those? Any questions? How do you plead?
Not guilty.
Do you want a lawyer appointed?
Yes.
Do you have a job?
Yes.
What do you do?
I'm a courier, I guess, is what you would.
Courier?
Yes.
Are you paid by the hour?
No, it's different, every route's different that you drive, so.
Who do you work for?
It's Mullet's Tri-State Delivery is what it is.
Okay, you have to help me out here. I have
Okay.
to determine your gross annual income.
I make about roughly $700 a week, but I do have 5 kids at home. I pay $700 in rent every month, and all of the utilities.
Well, they don't let me
I
count
didn't know
the
if you-
expenses. I'm only supposed to look at the gross income and the
Okay.
number of dependents that you
Okay.
have. That's what I'm supposed to.
I didn't know how much information you needed.
Okay, well, with 5 kids, that raises the amount that you can make quite a bit.
Okay.
And still get Porter County Council. So, I'll appoint Mr. Holt. Mr. Holt, this is Patricia Cook. It's a misdemeanor theft offense. I'm entering not guilty plea for her. She can sign a $1,000 signature bond. She will need to go to the jail to get fingerprinted. Do you have a date when you're going to be scheduled back here, Mr. Holt?
We'll be here Friday. After that, it's going to be quite a while.
This coming Friday?
Yes.
We can set it for pre-trial then if you want.
Don't believe I'll bring I'll probably have to file discovery on this. It would be the 23rd.
23rd, let's do that. That's not that far off. January 23rd will be the next hearing. Be a pre-trial at 10 o'clock. Not guilty plea is entered. Mr. Cooper's going to bring you a form you ought to take to the jail.
State of Ohio versus Jeremy Sloan, case number CRA 268, PRD 2631.
Jeremy Sloan? Yes, sir.
Sir, you're Jeremy Sloan.
Yes, sir.
Mr. Sloan, 26-8, case number alleges January 4th, Union Township, you know, obtained, possessed, or used Xanax, a Schedule 4 substance, and that you've got prior drug abuse conviction, so that makes this a felony 5, maximum penalty, a year in jail, $2,500 fine.
Xanax?
Yeah, that's what's in the complaint.
I got a Suboxone.
Well, I can only go with what they charge, so it may be wrong, but that's what they charge you with. Then you got a traffic charge also, 2631, alleges January 4th, 12:42 a.m. You're driving a vehicle, it's alleged with a suspended license. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you have the money to hire a lawyer?
No, sir.
Do you have a job?
Yes, sir.
What do you do?
I work at a scrapyard.
Paid by the hour?
Yes, sir.
How much per hour?
I make like $13.75 an hour.
Do you have dependents you're supporting?
No.
You're a single person?
Yes, sir.
How many hours a week are you working?
I work about 3.5 days a week.
Okay, so you're not working 40 hours a week?
No.
Okay, you're eligible for court-appointed counsel then. Mr. Morford, I'll appoint you.
There you go.
Mr. Sloan has posted a bond, so I'm going to continue his bond. And let's see, he probably was already been fingerprinted. Did you get fingerprinted at the jail?
I got bonded out right here.
Okay, so you never went to jail. Well, you'll have to go to jail to get fingerprinted. There is no fingerprint form in the file, so you'll need to go get fingerprinted. Mr. Cooper will give you a form to take to jail with you. I'll continue your bond.
Thank you.
And do you want to come back within the 15 days or go further out? Mr. Moore?
Further out, Judge, fine, we'll
He's gonna be out of
go.
bond. I'd say the 23rd is worse than I thought. The 20th, not the 23rd, 20th is a Tuesday. 20th or 26th are out.
Let's do 26.
26th is a Monday, so January 26th for preliminary hearing and pretrial at 10 a.m.
Your Honor, we need to make an amendment to the complaint.
Okay.
The officer's affidavit does indicate that it was Suboxone without a prescription. So we would move to amend Xanax to Suboxone.
Okay, you were correct, Mr. Slime. I'm going to amend the, if there's no objection, I'm going to
No.
amend the complaint to allege that he was in possession of Suboxone without a prescription rather than Xanax. Okay, we'll keep the same here, January 26th, 10 o'clock.
Yes, sir, we're coming back. Yes, sir.
State of Ohio versus Stephanie Taylor.
Thanks, sir.
You are.
Case number CRB 25760. That is Mr. Morford's case.
Okay, Stephanie Taylor. This had been set for the 29th, and selection was not here, but so this would be pre-trial today.
Yes,
Any explanation for not being here on the 29th?
Yes, I had surgery for an abscess tooth.
Okay. How can we proceed today, Mr. Morford?
Not much we can do, Judge. She hasn't had a chance to come in and watch the video. I'd like for her to have that opportunity.
Okay.
So it's fixed.
Yes.
The 20, want to do that 26th date we just set?
Sure.
Again?
Yes, Your Honor.
All right, at the defendant's request, it's set for January 26th.
Who is this, Your Honor?
Stephanie Taylor, 25760. May not, it wasn't on the docket, she had missed a hearing on December 29th. Case number is 25760. 25760.
Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus Tanner Collins on the recall. Case number CRC 2612, A, B, and C.
Okay, well, you tested positive for alcohol. But nothing else.
Well, she was candid.
So, you still want to stick with your guilty plea?
Yes.
Okay. Are you working
No, Your Honor.
and you're just 18? Are you out of school or is still in school?
I'm out of school.
Living at home?
Yeah.
Do you have, how do you pay for medical services? Do you have a medical card?
I do, but I'm not sure about it. I don't know everything about it.
Okay. Ohio Medicaid, as far as you know, you have a
Yeah.
Ohio Medicaid card? Well, I think you need to, you told the officer, and let me ask you this, is it true what he said, that you started drinking at, what did he say, 11 or 12, something like that?
Yeah. Yeah.
It's really not that, I mean, you think that's kind of shocking, but I've got Todd Davies is, Dr. Todd Davies is someone who advised me, he teaches addiction at the Marshall Medical School, for medical students. And he also does a lot of data collection from all the treatment facilities. They analyze what people say when they go in and give a history. The average age of first usage in Cabell County, which we're not much different than Cabell County, 6th grade.
Yeah.
So, people start abusing substances a lot of times really young, and that sets you up for a lot of problems down the road. So, I would like to address that now. Do you want to get clean?
Yes, definitely.
Okay. And you live in Ironton or outside? You got an Ironton mailing address, but I'm not sure where
I
you
live like right outside of Ironton.
Okay. So going someplace, Ironton's probably the best place for you to go?
Yes.
Who we got in Ironton that wants to work with this?
I can't remember the name of that rehab there, but it's like a Philly or something like that.
Bethesda.
Yeah.
Bethesda? Okay, so Taylor, you want to talk with him? Sure. This is a faith-based program. You're okay with that?
Yeah.
Okay. So I'm going to refer you there. That's going to be part of your order. Let's get this thing, you're 18. You can live a long time.
Yeah.
But if you go down this path and abuse alcohol and other substances, there's so much out there in our community, your chances of living a long life are not that good. So, and living what I guess I would say, successful life. You stay employed, don't have problems in your relationships, you don't have problems with your kids. Anytime you throw substances in on top of all that, it just makes things worse.
Yeah.
So let's take care of it and get you on the right track. Okay, so since you admitted, and we're not waiting to see the urine screen, I'm going to give you the minimum fine I'm allowed to give you. So it's still bad enough, $375. That's the minimum fine on this offense. I'll order you to pay the court costs. Now, you don't have a license, but you're not going to be able to get one for 6 months. I'll give you a 6-month license suspension. Have you ever tried to get your license?
No, I haven't.
Okay. Well, here's another thing. You're 18, and I'm old as compared to you, but I can still remember when I was 18, and I've learned a few things since I was 18. One thing I would say is, like, if I didn't have a driver's license, I think when I was 18, maybe I knew this, maybe I didn't. I kind of thought I was bulletproof. I wasn't. When you're 18 and you're driving down US 52 at 4:30 in the morning, at 87 miles an hour, and you don't have a driver's license and you've been drinking, bad stuff is probably going to happen to you. Like the OSPs out there, what are they looking for at 4:30 in the morning on US 52?
Exactly what I was doing.
Exactly what you were doing. You might as well have a big flag that you were waving out. Make it easy for them. Just get a big flag that says, "I'm drunk, pull me over," because that's what you're doing. You're going 87 miles an hour. They're going to pull you over.
Yeah.
And then they're going to find out you've been drinking. And then they're going to find out you don't have a driver's license. You got to use your brain.
Yeah.
You've got a brain for a reason. You got to think about things. This is probably not a good idea at 4:30 in the morning to drive. You shouldn't be driving anyway. If you're going to drive, you better be below the speed limit. You ever heard of probable cause? It's a thing in our country. The Fourth Amendment gives you a right against unreasonable search and seizure. But what that means is they have to have a reason to pull you over.
Yeah.
You gave them a big reason, 87 miles an hour on US 52. That's not reasonable. This is dumb.
Yeah.
This is dumb. But you can learn. You know, you're young, you can learn, you can go on, start making good decisions. This was a really bad decision. So start making some good decisions. So part of it is let's get this alcohol thing taken care of and change your behavior also. What do you want to do with your life?
Not what I'm doing now, anything.
You want to get a job?
Definitely.
Okay. Well, this won't stop you from getting every job, but there might be some jobs that stop you from getting.
Yeah.
And the more of these you have, the more employers are going to say, you get another one, then there's going to be even more employers that say, Nope, I'm not getting involved with somebody that's got that kind of thing, so. Things that you do have consequences.
Yeah.
Okay, so, but you should be able to recover from this one. You make a mistake, learn from it, go on. And, I mean, if you get your license and try to get insurance, it's gonna be hot. It's gonna be really hot once you get one of these and you're a young male.
Yeah.
High risk, you're in the high risk category. Okay, so 375, 20 days in jail. I'll suspend all of your jail days, but you gotta do some stuff. You get your jail suspended. Here's another thing where you could, you know, you gotta use your brain and think, I don't wanna go to jail. You do not wanna go to jail. It's not a nice place. So, what do you gotta do? 5 days of community service. We have a community service program here. You come here, summer you'll cut grass, wintertime pick up litter, do whatever to get your 5 days done. You can do it any day, that's Sunday or a holiday. You'll have a review hearing July 27th, and it's going to be on your paper. You have a smartphone.
I do.
Everybody has a smartphone. So what that means is there's no excuses, because I'll get people, they get arrested for not coming to the review hearing and say, well, I forgot when I was supposed to come back for it, or I lost my paper. That, if you got a smartphone, we got a website, you can go. We actually have phones. And you can't text the clerks. I know people your age like to text, but you can call them and they will answer the phone and tell you when your hearing is. Or you can get on your smartphone and pull up your case and it'll show you when your hearing is. So there's no excuse for not coming to your hearing. You gotta get it done. You gotta get done what your orders do. So 5 days community service, you got fines to pay. If you don't have a job and you can't pay your fines, you can work extra community service and work it off.
Right.
Okay?
I'm sorry, can you put that review in July?
July's okay.
Okay.
Oh, no, you're right. Let's do it about 6 weeks out. So let's go mid-February. So your first review hearing is going to be in February. So I'm ordering you to go to Bethesda, get treated for alcohol issues, and you'll come back for a review hearing on the 17th of February. That's a Tuesday. Usually it would be the 16th, the 17th is a holiday. Then on your driver's license, if you're not having a driver's license, $50 fine and 2 extra days of community service, not having a driver's license. And then on the 87 miles an hour and 55, I'd like to give you the max fine, but you don't have any money. I mean, that's, not only is it stupid, it's dangerous for you and everybody else that's out on the road. You're going 87 miles an hour after you've been drinking. Okay, I'll give you a $50 fine on that. Any questions?
No, sir.
Go see Mr. Major, probation officers, go out in the lobby, 90-degree left turn, west side of the building, that counter over there, is probation. Go tell him your name and that you're, got to meet with him, and he'll give you your paperwork.
All right.
Okay.
Thank you.
State of Ohio versus John Davis, case number TRD 252480 A and B. John Davis.
Okay, we'll pass John Davis, he is here. We'll pass it for now, he's not in the courtroom.
State of Ohio versus Roderick Lewis, case number TRC 213039 A and B.
This is on a review, it looks like, Mr. Royce had failed to appear before in a review, I think.
Yes, sir.
Now he's at counseling center.
That's correct. This is a gentleman I spoke to about Friday, Your Honor.
Okay. He's inpatient.
Yes, he's in transitional, Your Honor. He's actually about to start working.
Okay. So he's been there for a while, it just didn't click that he needed to come back to court, correct? Okay, so he's here now, doing well.
Yeah. Yes, sir.
So that's good, I want to encourage that. You've got, as of now, you got 5 days of community service you still owe, and you owe $670 on your bond.
Yeah, I just paid about $100 online. They said it wouldn't show up though until
Yeah, it takes a
tomorrow.
day for them to show up when you pay it online. Okay. You were also ordered to go to the driver intervention program. Here's what I'll do. If you complete at the counseling center and get me proof of that, I'll let that stand for you going to the driver intervention program.
Okay.
Because that would be more hours anyway, what you've done there than what you would do at a 3-day weekend school. So, I encourage you to get clean, stay clean. So, looks like you're on the right track. I'll withdraw the warrant. There had been a warrant outstanding for you. I'll withdraw that, give you a new review hearing date. Let's make him February 17th. That's Tuesday, so that's unusual. Usually it's Mondays and Fridays, but there's a holiday on the 16th. So February 17th is his next hearing, 9 a.m.
Thank you, Your Honor.
Thank you, sir.
You're welcome.
Your Honor, that's all the items we have for now. We're ready to start some pre-trials.
Okay, we're starting the pretrial docket.
State of Ohio versus Kendra Brown, case number CRB 25221. That is Mr. Holt's case.
Kendra Brown, set for pretrial. This was my notes were a 90-day with Paul's case.
She paid today, Your Honor, and she came to court, she had a surgical.
State still willing to dismiss?
Yeah, the costs have been paid, so yes.
Case will be dismissed.
Thank you, Your Honor.
Thank you.
State of Ohio versus David Moore, case number TRC 252771. David Moore.
Your Honor, Mr. Moore left a message to my office early this morning. He lives out back of Ashland. I have met with him. He was able to get a ride today. I asked that he continues to Friday, since I will be here Friday.
Deal.
We're okay with that, Your Honor.
Okay, at the defendant's request, we're going to continue this hearing to I'm looking at the wrong number. So that's going to be the 9th of January. Yes, you finished the part. January 9th will be the next hearing for pre-trial.
State of Ohio versus Taylor Bryan, case number CRB 23-112, CRB 20-112.
Mr. Smith's case. Yes.
That's complete. We don't. It's a 20.
About your business. Here you go.
Okay, good job. You got a vehicle now, and you got a job, and you're going to start working on your community service.
Yeah, I already did. I got 8 hours in.
Okay, very good.
Roughly 30 days, Judge?
Yes.
I'm here the 6th or the 9th of February.
Okay, let me look at it.
Recognize that you were gone.
Let's do the 6th.
February 6th.
February the 6th will be the next hearing.
Head towards the finish line.
Thank you, Your Honor.
Okay, good job.
State of Ohio versus Joshua Harris, Case number CRB 25-741, CRB 21-583, CRA 21-289, and CRB 21-290.
This is Mr. Smith's case.
He sent this thing.
Judge, I had a snafu in my office. He's coming this afternoon to meet me. The here it is this morning. I've talked to Price, if we could come back, I'm here Friday, as soon as Friday, if that's not too busy, or I'm here the 23rd.
Let's do Friday, that's the 9th. January 9th will be the next one.
That'll give me time to talk to him. Thank you, Judge.
You're welcome.
One thing I would like to make sure that is, I'm correct on, and that is, it appears to me that on 21-290 and 21-289, that way back in, on August the 9th, 2021, he pled guilty.
That's
So-
my notes also.
And sentencing was pending, and we never had the sentencing, so. That's all, I want to make sure.
Talk that over. And
We want to talk
Friday.
that, we'll be back Friday. Yes, Judge. Thank you.
January 9th is the next one.
Should I write that down there? Did you tell me?
What's this Friday? I'll write it down.
Yeah.
He's head over to talk to him. He'll take some notes.
Okay.
State of Ohio versus Selena James. Case number CRB 25-822, Selena James.
Mr. Smith's case, pre-trial.
It is, Judge. I have not had contact with her. She was at OVP. I guess she's not there because of the allegation. I filed discovery this morning. I was going to ask for a continuance.
Oh, she's the last, I remember now, yes.
Yes.
She was in domestic violence shelter and checked herself into OVP, and then there was an issue there. I got contacted by the jail that said she had a pretty severe infection of her arm, and it was recommended that she be admitted inpatient at the hospital, so they wanted to discharge her for that. That's happened on, well, before January 5th, when she was ordered in on January 5th, which is today, so sometime within the last week. So,
I just don't know where she is to,
I'll issue a warrant for her. I mean,
I'll see what I can do.
sorry for her, she didn't have a place to go.
Right. I remember this.
She didn't have a place to live, and
Yes, sir.
I was concerned about that. Warrant will issue for failure to appear.
I'll see what I can do to find her.
She could still be in inpatient hospital.
Yeah, but I don't know if I can find that out, I might check with the jail, see what I can find out, or OVP.
State of Ohio versus Christina Markham. Case number TRC 25-2397, A, B, and C.
Mr. Smith's case, pre-trial.
Judge, this is a case that there were actually two tests done. One was for alcohol, which I understand was negative. There was a paraphernalia test was negative, but the actual drug test results are not available as of this morning. Is that correct?
That is correct, Your Honor. They actually, the officer actually collected a sample of the alleged contraband in the car, and it was found to be free of any substances. The urine test was tested both for alcohol and drugs. The alcohol test came back with no alcohol. So we're still waiting for the urine screen having to do with drugs, has not come back yet. The stop was on September 13th. So the 90 days,
It's fast approaching.
it's, yeah.
How do you want to proceed?
Well, I think that it probably would be fair to all concerned if we came back maybe at the end of this week, if Mr. Smith. and-
I'm here Friday, Judge. If
and
not by
Mark are
Friday,
available.
I would anticipate a nollie on Friday if it's not available.
Okay, it state's request is continued January 9th for pre-trial.
This Friday.
State of Ohio versus Nicholas Pope.
This
Case
Friday
number
at 10.
CRB 25-734.
Mr. Smith's case.
I think so.
Sounds good. Judge, this is a case that we pre-tried this morning, and it's my understanding the state's going to agree to kick this out 90 days if there are no further issues and my client pays court costs, it'll be dismissed at that time.
And we have consulted with the victim, and the victim actually wants us to go ahead and dismiss it now, but we're not willing to do that. We have a case that I think we could prove if we had to. So we're okay with a 90-day continuance and a dismissal with payment of costs if there are no further problems.
So that's April.
Yeah, Judge, you just tell me when I'll be here. I have nothing set.
Okay, let's do the 10th, April 10th.
Okay. Down April 10th.
If there's no further problems and costs are paid, it'll be dismissed. And since there's no TPO, he doesn't have to appear if there's no chapter.
Sure.
Oh, okay.
State of Ohio versus Anna Schaefer. Case number CRB 24-549 A and B, CRA 23-442 A and B, CRB 23-443.
Smith's case, pre-trial, and there's also only she's at Lawrence County Recovery.
Yes, sir.
Got a good report from them, good screens, and making progress, it sounds like.
Thank you, Your
Very
Honor.
good.
Thank you, Your Honor.
So, it doesn't say she's finished, it says she's making progress. I assume we need to continue to monitor her situation.
I think it'd be appropriate, Judge, yeah.
What's
About
what's your
30.
schedule in February?
I can do the 6th, 9th, and 13th.
Let's do the 9th, February 9th.
10 o'clock.
For preliminary hearings and pre-trial.
Thank you, Judge.
You're welcome.
Thank you.
Your Honor, we're ready to go to Lawrence County Jail.
Okay, we have some hearings we're going to do at the jail by teleconference.
State of Ohio versus Kenneth Busker, case number CRA 25829, CRA 25600.
Sir, are you Kenneth Busker? Ms. Busker? It's Mr. Smith's case, set for preliminary.
Yes, Judge, he is being held by Boyd County, Kentucky on a parole violation. I spoke to Mr. Hill this morning. We have come to an agreement. This would be like a 90-day continuance situation, and hopefully there's no further issues, dismissed on payment of costs. But I guess now that we've got something done on this one, that Kentucky would probably come get him here within the time frame Your Honor would set for Boyd County.
Okay, I have in the file, there's a warrant issued by the Kentucky Parole Board.
Correct.
And
We might need our waiver form. I know when he was placed on parole, you signed that boilerplate that I will not fight extradition if I get arrested.
Okay.
But he might need one of our forms as well, but he can't. He can't
execute that?
Yeah, he cannot post the bond. I've already asked him this morning, so we need a time frame for them to come pick him up.
What's, so we're going to dispose of 2,500 is the case pending here? That was the domestic violence?
Leave it pending, Judge, for 90 days and let him get to Kentucky and try to clear up whatever that situation is.
He had posted a bond, through Mr. Sowers at $5,000 on that charge, so we could let that remain in effect.
Unless that keeps him from being able to go to West Virginia. We're okay with him going on to West Virginia.
Kentucky.
He's Kentucky. Boyd County.
And I'd like to explain the circumstances, Your Honor.
Oh,
On
sure.
the same date and time that this charge arose, Kenneth Buskirk was alleged to have assaulted Stephen Davis. Well, at the same time, Stephen Davis is alleged to have assaulted Sandra Buskirk, who I believe might be the spouse of Kenneth Buskirk. His mother, okay. So anyway, we put that case on a 90-day continuance.
Okay.
And that case is set for February the 9th. And I guess what I was thinking was that we would put this case on February 9th as well, understanding that Kenneth Buskirk may not be available. He may be in Kentucky and dealing with the courts there.
Right.
But that we're looking towards a dismissal with no further problems on that case also.
I'm here on February 9th, Judge, that's fine.
We can put it in for a status conference. So what I'm thinking to do, he has his bond up on the case pending here. He can sign a waiver of extradition.
Yes, sir.
And the warrant here should be released. Kentucky notified he's available to be picked up.
Yes, sir.
And give them a week to do that. And they may need longer because it's not Boyd County, it's the parole authority.
Oh, okay, he thought it was Boyd County. It may have started in Boyd County, you're correct.
Yeah, the case may have started there,
Yeah.
but the warrant is actually
Sure.
issued by the Kentucky Parole.
Probably
Board.
Frankfurt.
So we need a waiver of extradition form. So we'll have the waiver of extradition form sent to the jail for Mr. Busker to sign. That's on the 25/8/29. I need to set in for another hearing just to make sure they have picked them up. When are you available, next available?
I'm here this Friday, Judge.
Well, that's too fast.
Then I go to the 23rd. I've got a couple trials. If it's just to see if he's picked up, I'm sure I could have somebody cover if you don't mind.
Why don't we set it for the 12th?
Okay. I will find someone to.
And if the jailers looking in, which I assume they are, notify Kentucky he's available to be picked up, and they try to leave to pick him up. They need more time. They need to give us a reason for that.
Your Honor, I'm available the 12th, and
Could you cover that?
Mr. Smith, you did that for me, so I'm happy to return the favor.
Great, thank you.
put him back on our docket for January 12th, and then on the 25-600, what was it, February 9th?
9th, yes, sir.
February 9th for it.
No, that's not 600.
Your Honor, is there a way for me to file?
I mean, I know that's what we have. I don't think that's right.
Yes. Okay. Mr. Smith, there's already a waiver.
Oh, okay.
Here, so,
Your Honor, what's the case number on the domestic violence charge?
600, 25-600. I'll put a note on here to fax it to the jail.
I'm sorry, what are we doing with 25-600?
Put it on February 9th for a pretrial.
State of Ohio versus Marcus Davis Senior, case number CRA 2613 AD and C. Davis on deck.
So are you Marcus Antonio Davis?
You said what?
Is your name Marcus Davis?
Yes.
Mr. Davis, I'm Judge Capper. This is your arraignment. You are appearing in the courtroom on a monitor, and everything you say is being recorded. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state of Ohio prove the charges they're filing against you beyond a reasonable doubt. You understand these things?
Yeah.
Okay, you've got 3 charges. 2613A is aggravated possession of drugs charge. It alleges that on January the 5th of 2026, you knowingly obtained, possessed, or used a controlled substance, and that substance was methamphetamine. So that's they've charged it as a first-degree felony because of the amount. It's alleged you had a large amount of this substance.
I didn't get caught with anything, sir.
Well, they may not be able to prove what they're alleging. I'm just telling you what they're alleging. I don't know if it's true or not, but you need to understand what you're charged with.
Oh, okay.
A first-degree felony carries a maximum penalty of 10 years in jail and a $20,000 fine. The second charge they filed against you is failure to comply with the order or signal of a police officer. They're alleging on January the 5th, Fayette Township, you operate a motor vehicle to willfully flee or elude a police officer after you were given a visible or audible signal to bring your vehicle to a stop. That is a felony of the 3rd degree. Maximum penalty is 5 years in jail, $10,000 fine. And then the final charge is tampering with evidence. It's alleged January the 5th, Fayette Township, knowing you were being investigated or an investigation was about to be started, they're alleging you altered, destroyed, concealed, or removed something to impair its availability as evidence. So that's tampering with evidence. It's a felony of the 3rd degree. Maximum penalty, also 5 years in jail, $10,000 fine. Do you understand these 3 charges?
Yes.
Do you have the money to hire a lawyer?
No.
Do you have a job?
Yeah,
What do you do?
I have my own business. It's a photo company.
Photo company, is that what you did?
Yeah, photography.
I've got to determine what you make in a year. Do you know what your annual income is?
Well, I just started, so it's less. I probably say probably not even 10K. I just started.
Okay. Did Mr. Holt leave? Is he still here?
Yes, Your Honor.
To represent Marcus Davis at F1. This is the most serious charge. But aggravated possession of drugs, they call it an F1. He's got 3 felonies. One, the other most serious is failure to comply. What's the state's position on bond for Mr. Davis?
The state requests a $75,000 cash surety bond.
Okay, I'll set bond at
Can I
$75,000.
get a bond? It's too high. I can't.
I'll let you talk to your lawyer about it. If he wants to have a hearing on it further, we can do that later in the docket, but I'm going to set that for now. $75,000. Mr. Holt's going to be your lawyer. He's here in the courtroom listening to what's going on. He came in today, I think, at 10. Yeah. So we need to have the hearing within 10 days. What's your...
Trial here on Friday.
You're here Friday?
Yes.
Okay, we'll set it for this coming Friday, the 9th, for preliminary hearings, 10 o'clock. You want the court's file?
Yes, sir.
All right, sir, your lawyer's going to call down and talk to you, and if he wants another hearing, we'll have that later today. If not, you have a preliminary hearing set for Friday, this coming Friday.
State of Ohio versus Dana Howard, case number CRV 24235, and Paul Lewis is on deck.
Okay, you're Dana Howard?
Yes, sir.
All right. Mr. Howard, I had ordered you to fail to appear for a review hearing previously, and May 23rd of this year, I ordered you be sentenced to time served then and come out the next day to do community service, and I was going to suspend the court costs and close your case if you did that, but you didn't. You didn't do it.
Your Honor, if I may, he did call me that morning and said he was going to be here the following week and never showed up.
Okay. What do you say about that, Mr. Howard?
I was going to say, I cannot hear you very well at all.
Well, what I'm saying is you had previously appeared in court back in May and said I ordered you to come out and do 1 day of community service, and your case was going to be over, and you didn't show up. You did?
Yes, sir, I was homeless, I had a car accident, and I could not make it. I'm so sorry.
Okay. Because you live in Chesapeake, right? Or you were living in Chesapeake?
I was living in Chesapeake, yes, sir, but at that time I was not. I had to go stay with my sister because I had no place to go.
How long you been in jail this time?
Sir, I really don't remember.
Okay. More than 1 day?
Yes, sir.
Where
Yes, sir, yes, sir, it was a week, sir.
If you weren't in jail, where would you be? Where you got a place to go to?
I would have to stay with a friend or something.
Where would that be?
Sir, I could stay at my sister's house again right now if I had to.
Where she lives?
That would be Mason, West Virginia.
Oh, that's pretty far away. How you gonna get to Mason, West Virginia?
So I have a crack opportunity.
Okay. All right, well, I'm gonna finish your jail time this time, we'll finish it up. Your case is completed. I'll release you from jail. Case completed by jail.
So thank you so much, sir.
You're welcome.
Bye-bye.
Bye.
State of Ohio versus Paul Lewis, case number TRC 252119, A, B, and C, and Kenneth Malone is on deck.
Sir, you Paul Lewis?
Yes.
Mr. Lewis, I'm Judge Capper. This is an arraignment hearing for you. Mr. Morford is your attorney, and I have noticed in the file from November of this year alleging that you left the counseling center. You were getting counseling at the counseling center, and you left treatment, and a warrant got issued for you. It looks like you got picked up on the warrant.
Yeah.
So, your lawyer, Mr. Morford, is here. He's in the courtroom right now. We'll let you talk with him. This is a pending, you have a pending felony and a pending ODI. So, see what the felony is. What is the felony? You have
Possession.
possession charge. Well, I think we just need to set it for another hearing. What's your schedule, Mr. Morford?
Judge, I'm good through March, pretty much.
Okay. I'm going to set it for a week from today. And I'm going to give him a new bond. Since he left treatment and didn't come to his hearing, you now have a $5,000 cash assurance bond. Oh, did?
2,500.
I'm sorry?
2,500.
Okay, well, I'm going to make it 5,000 now. Your new bond is 5,000 cash or surety. And you have to be here on January the 12th, which is a week from today. Your preliminary hearing and pre-trial.
State of Ohio versus Kenneth Malone, case number CRA 1814, CRB 1815 A and B, CRD 162229, CRD 161524 A and B.
These are all arraignments. Sir, are you Kenneth Malone? Mr. Malone, can you hear me?
I can't hear you work. No. Can you turn this up?
Okay, I can hear you just fine. Okay, how about now? Can you hear me now?
Yeah, I hear you, sir.
Okay. I'm Judge Capper. This is what's called the arraignment hearing for you. We're going to go over the charges. You got new charges filed. We're going to go over those. Well, looks like they were old charges, but I don't think you've ever been arraigned on them. Okay. Old charges that you never got arraigned on.
Yes, probably.
You have a right to remain silent. You don't have to say anything. If you do make statements, it's on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove the charges against you beyond a reasonable doubt. You understand those things?
Yes, sir.
Okay, we'll start with 1814, 1815, 1822.
Okay.
1814, that's the case number, alleges that on February 1st of 2017, in Rome Township, you knowingly obtained or possessed marijuana in an amount exceeding 200 grams. So that's a felony 5 amount. Maximum penalty was a year in jail, $2,500 fine. 815A alleged that on February 1st, 2017 in Mason Township, you operated a motor vehicle to willfully elude or flee a police officer after you were given a visible or audible signal to bring your vehicle to a stop. That's charged as a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. 1815B alleges that at Rome Township, February 1st, 2017, you possessed 16 sets of untagged wild white-tailed deer antlers. That's a violation of possession of deer parts. It's a third-degree misdemeanor. Maximum penalty, 60 days in jail, $500 fine. 15C alleges that Mason Township, February 1st, 2017, you did dispose of garbage, waste, rubbish in a stream, river, lake, or water course that is polluting a state land or water resource. It's a third-degree misdemeanor. Maximum penalty 60 days in jail, $500 fine. So you have not been arraigned on all those charges. Do you understand those charges?
I guess so, sir.
Okay, and then you had also an old case that you had a warrant outstanding on, 163487, which was a traffic charge. Driving without a license. You were supposed to be in court on August 29th, 2016, and did not appear by warrant because it didn't appear. There was also another traffic charge, 162229, and it's alleged on that you failed to appear the same day. You were supposed to appear the same day for sentencing. That was also another driving under suspension. And then also a case 161544 was a driving under suspension that you failed to appear for. So those are all pending.
Yeah, I had to go to work, sir.
Okay. Do you have the money to hire, are you still working? Do you have a job now?
I've been working for Raymond Gorby. I was working for Drew Clark.
Okay.
If I get all this figured out, I believe I can go back to work for Drew Clark.
I know both those people.
What is it?
I said I know both of those people, Drew Clark and Raymond Ward.
I
Okay, so how much money do you make working for them?
Not enough. I mean, I ain't got no diploma, but I make about, Drew Clark pays me $450 a week when I work for him.
Okay, that's probably seasonal though, isn't it? Are you working now?
He was paying me year long, but I don't know what'll happen when I go back, you know.
Yeah.
I know I got two children, sir, that really need their dad.
Okay, that's the magic word, 2 children. So I'm going to appoint Mr. Stratton to represent you.
Who's that, him?
He's a lawyer. He's right here. He's been listening the whole time.
What's his highest level? Does he have a felony, Your Honor?
He does.
And what's that? F3?
That was the marijuana.
Oh, was that the marijuana? Okay.
Because of the amount it allegedly possessed. So what's the state's position on bond?
Well, I mean, the fact that it's 6+ years old and he didn't come to court before because he had to work in 2016, probably worthy of actual cash or surety bond at this point. We also have maybe an idea of how to resolve it. I don't know if Mr. Stratton would be prepared to do that today, but.
Well, it can't hurt for you to put that out there. You got something you want to propose?
First thing I'd like to know is how long he's been in jail this time.
When did you go into the jail, Mr. Malone?
I was here Saturday morning about 1 o'clock, 2 o'clock.
So we would be willing to amend the felony marijuana possession to a misdemeanor.
That would be great, because I love my children.
If he were to plead to all of the charges and receive a sentence of 60 days in jail, of which he would end up serving 10 days. So you'd have about 8 more days to serve. And we would ask for the forfeiture of the antlers. I'm sure that would be.
I don't have no antlers. Most of them antlers that was there, I cut off the deer that was on the side of the road, get down there through Clark. When they get hit on the farm, I just cut the horns off.
I'm going to let Mr. Stratton's going to call down and talk to you, and then we'll come back after you all talk and decide how we're going to go forward. So he will call and talk to you. Yes.
State of Ohio versus Brandon Scragg, case number CRB 21524, CRC 2715, and Lee Shepherd is on deck.
Okay. Brandon Scragg is Mr. Stratton's case. And he had failed to appear back in April the 8th, is the last he failed to appear.
He was at LCR, Your Honor, and then...
Left?
Yeah.
Okay. And let's see, well, he's got an OVI that he's already pled to, and it's pending.
Yeah,
If I may say something, when I have a chance.
I'm looking at the call now, and your lawyer probably would prefer you not say anything.
you can tell me when we get on the phone, and then we can call it back. So just let the judge do what he does.
Well, I think, I'm looking at the screen that led to him going to treatment. It looks like this treatment was warranted from his screen that he did previously. Why don't you talk with him, let's come back and decide how we're going to go forward. We'll recall this later in the document. So your lawyer's going to call down and talk to you, Mr. Scragg.
Okay, thank you.
You're welcome.
State of Ohio versus Lee Shepherd, case number CRA 2609, CRB 2610.
And this is for arraignment. So are you Lee Shepherd?
Yes, sir.
Mr. Shepherd, I'm Judge Capper. I'm the judge at the Lawrence County Municipal Court in Chesapeake. That's where the charges are filed. And we're doing your arraignment today. Can you hear me okay?
Yes, sir.
You've got some charges, but before I tell you what the charges are, I got to tell you your rights. You have a right to remain silent. You don't have to say anything. If you do make statements, what you're saying is on the record, it can be used against you. If you want to talk about your case, it's better to get a lawyer to talk to the lawyer, because what you say to the lawyer is privileged. What you say in open court is not privileged. It can be used. You have a right to have an attorney appointed. If you can't afford one, you have a right to have bail and to make the state of Ohio prove the charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Looks like the most serious charge is strangulation. It's a felony of the 3rd degree. Carries a maximum penalty of 5 years in jail and $10,000 fine. It alleges that at Perry Township on January the 2nd, 2026, you created a substantial risk of serious physical harm to Leanna Gerald by means of strangulation or suffocation. Then you've got another charge, 2610 is the case number on it. And it's a domestic violence charge. It alleges that on January 2nd in Perry Township, you knowingly caused or tried to cause physical harm to Leanna Gerald, and that Ms. Gerald is either a member of your family or she lives in your household. That's what makes it domestic violence. Maximum penalty for domestic violence is charged against you is 6 months in jail, $1,000 fine. So you've got 2 charges. Do you understand the 2 charges?
Yes, sir.
Do you have the money to hire a lawyer?
Do I have money to hire a lawyer?
Do you have money with which you can hire a lawyer?
Yes, sir.
Do you have a job?
I'm disabled.
Okay. I'll appoint Roger Smith to represent you.
No.
I didn't know. Well, I'm glad you came up here. I was going to ask if you were here anyway.
Mr. Smith is here in the courtroom. He's going to be your lawyer. And I'm assuming this must be Ms. Gerald.
It is, Your Honor, and she's urging me that this is all a big mistake. I don't think she wants a protection order. So, other than that, and we would not be requesting a cash or surety bond. We'd be okay with no R bond, given that she doesn't want a protection order.
I just want to confirm that on the record, ma'am. You are Ms. Gerald.
Yes.
The complaining party in this
Yes, sir.
case that's been filed. And you do not want Mr. Shepard ordered to stay away from you.
No.
What is your relationship to him?
He's my baby's dad. My baby's dad. My
Okay.
boyfriend, yeah.
All right. So, all right, Mr. Shepard, you won't be ordered to stay away. You can go, you all live together?
Yes.
You can go back. I don't want there to be any allegations of additional harm, or I don't want anybody to get hurt. That's the main thing. So I'm going to let you out on a signature bond. Mr. Shepard, I'll make it a $5,000 signature bond. What that means is you're just going to sign a piece of paper that says, I promise to come to court when I'm ordered to, or I'll pay a $5,000 penalty. Plus I'll get a warrant for not showing up, so.
Like his number?
His number, his.
His is 216-376-6344.
Ms. Gerald is giving your phone number to the lawyer. I assume you're okay with that?
Yes, sir.
Yeah, I'm going to call you when you get out of jail, so we'll set up an appointment before your next hearing is to speak.
When do you want to come back for the next appointment?
Judge, I'm here the 9th, or not again until the 23rd due to my crazy trial schedule in
Are you
January.
willing, since there's no protection order, he's out on bond, you willing to waive?
Yes, Judge, we'll waive. Since he's getting out, I have no hesitation to waive.
Okay, Mr. Shepard, I'm saying your next hearing, January 23rd. So that's 2.5.
Sorry.
2.5 weeks from today.
Oh, okay.
I'm sorry?
I was wondering if I had like a copy of the days.
Well, if they write it down for you, but
I will call you, I'll get you in before the 23rd, and I'll give you a reminder when to be in court next, but I'm going to call and get you in before then.
I think we're clear this.
Okay, so be expecting my phone call, probably this afternoon or tomorrow morning. I'll call you.
Mr.
Yes, sir.
Shepard.
I didn't need these cards, but I will make sure.
Okay.
Mr. Shepard, do you know where the court is in Chesapeake?
Yes, sir.
Okay, so that's where you gotta come to on the 23rd. And if you get confused about the date you're supposed to be here, you can call the court, or if you have a smartphone, you can go online, the court has a website, put your name in the record search, and it'll show you the date that you have to be back. Okay?
Yes, sir.
January 23rd at 10 a.m. will be your next hearing. And Mr. Smith's going to be your lawyer.
I'll be in touch.
Okay, thank you.
Thank you, Judge.
State of Ohio versus David Ward Jr., case number CRA 2611, CRB 2612.
This is an arraignment also. Sir, are you David Ward Jr.?
Yes, sir.
Can you hear me okay, Mr. Ward?
Yes, sir.
I'm Judge Capper. I'm at the Lawrence County Municipal Court, which is in Chesapeake, Ohio. So you're appearing in this court today on a monitor. Your image and what you're saying is in the courtroom. Everybody that's in here can see you and hear you. And it's also being recorded, so what you're saying is going down on the record. You don't,
Yes, sir.
You need to understand you have a right to remain silent. You don't have to say anything. But if you do make statements, it can be used against you if you admit something about your case. There can be a video of you saying those things, so.
Yes, sir.
You have a right to have an attorney, and what you tell an attorney is privileged. What you say in open court is not privileged. So you got stuff you want to talk about, it's best to get a lawyer and tell them. You have a right to have bail, make the state prove the charge beyond a reasonable doubt. And if I didn't say so, you have a right to have an attorney appointed if you can't afford one. Do you understand those things?
Yes, sir.
Okay, let's go over your charges. You may not agree with them, you don't have to agree, but you need to understand what you're charged with. First and most serious charge, 2611 is the case number, and it's having a weapon while you're under disability. The state's alleging that in Fayette Township on January the 2nd, that you were under a disability from having a weapon and that you did knowingly acquire, carry, or use a firearm because the disability was being under an indictment. So that's a felony of the 3rd degree. Maximum penalty is 5 years.
Can you repeat that? I didn't understand what you said.
About the charge?
Any of that, I didn't hear any of it. Something about a weapon or some or another disability?
Yeah, they're alleging that you were not allowed to have a weapon because you had been under indictment. So they're saying that you had a weapon while you were not permitted to have one. So that's the charge.
Okay, so they said I had a weapon while I was on this, on indictment, I guess?
Yes, that's my understanding.
Okay.
And that is a felony, the 3rd degree. It carries a maximum penalty of 5 years in jail and a $10,000 fine. That's the maximum.
Okay.
Now, that's case number 2611. Now, you've got another charge, 2612. It's a misdemeanor charge, being in possession of drug paraphernalia. It alleges January 2nd this year, Fayette Township, you knowingly were in possession of drug paraphernalia, being a glass pipe with drug residue in it. That's a 4th degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand that charge?
I just, I'd like to know what drugs were in it, what residue was found in it.
I don't know. They don't say in the complaint, so.
Okay.
Do you have the money to hire a lawyer?
No, sir.
Do you have a job?
I was about to start at Superior Welding, but I don't know if that's gonna work out now.
Okay, so you haven't been working up till now.
I mean, I also work at Merchandiser Franchise, which is a phone app that I go store to store and do inventory, stocking, and exchange. So, yes, sir, I have been working up till now.
Well, I need to know, I have to determine how much your income is. Do you know what you're making in a week, a month, whatever? Because
right now it was about $1,000 every 2 weeks. It was a side job, more or less. It wasn't full time. It was part time. So, yeah, maybe $1,000 every 2 weeks, maybe.
okay, are you supporting, do you have children you're supporting?
I have 2 children, yes, sir. Am I supporting them the best I can? Yes, sir.
Okay.
And are those only 2 charges?
Those are the only 2 charges that I have.
Where's the burglary?
I don't know. They didn't charge burglary. I haven't seen it yet. Is there a burglary coming, Mr. Healy?
They determined that there's a 2009 indictment for burglary out of Santa Rosa County, Florida.
Santa Rosa? That's Florida.
Right.
What was that?
Charged with this offense when he was a juvenile.
Oh, yeah. Yeah, it was a very long time ago.
So that's still out there?
Yes, so I guess the court
How is that still?
have a request.
Well, apparently there's a warrant for you. Mr. Morford, I'm going to appoint you to represent Mr. Ward.
Well, you said there's a warrant for that out of Florida?
Is that correct?
That's what That was the reason that they actually went to find him, for some reason.
Okay.
For real?
Okay.
Wow, hold on, see, so the paperwork that I have here, sir, says it was a burglary for something completely different, so.
What's the state's position on bond for Mr. Ward?
Well, I think the state, under the circumstances, would be highly interested in making sure that if Santa Rosa County, Florida wants him, that he be made available, but I don't know that the court has anything on that.
Well, if there's something out there, that's probably gonna be a holder anyway, so.
Yeah.
But on the charges in Ohio, what do you want as a bond?
Well, we would ask for a $5,000 cash or surety bond.
Can we get 10% then? I mean, I don't have 5,000.
Well, here's how that works. I'm gonna set it as cash or surety, so that means if you do have 5,000 in cash, you can deposit that with the clerk, and as long as you show up for all your hearings at the end of the case, you get the entire 5,000 back. If you can't do that, and a lot of people can't, then you can use a bail bondsman. That's the surety part. You use somebody that guarantees your appearance. You give them a fee, usually it's 10%, and then they keep that money, $500, but then they're on the hook if you don't show up, and they don't like being on the hook if you don't show up. So they'll track you down, usually, and arrest you if you don't show up for your hearing, and take you to jail. So, do you want to talk to a bail bondsman? You think you can post a surety bond?
Okay. I'm so confused. This burglary is out of Santa Rosa County, Florida?
That's what the prosecutor's telling me.
2009. As a
2009? This is absolutely insane, because I have not.
I'm telling you, sir, as your lawyer, I'm telling you, you're probably not say anything.
So I need to be transported to Santa Rosa County, Florida?
Why don't you talk to your lawyer, sir? We're not going to work here all the little details out here in open court. We're in open court right now.
Okay.
So you need to talk to your lawyer about it, and what you tell him and what you all discuss is not in open court, and it won't be on the record, and it can't be used against you. You might work something out here that's helpful to the state. So I'm going to set his bond at 5,000 cash or surety. We can set it for hearing next. Let's see if that's going to work. How long have you been in jail, Mr. Ward?
Since Friday, sir.
Okay. Yeah, so the 12th works. So I'm setting it for January 12th, Mr. Morford. Thank you. January 12th for preliminary hearing and pretrial. And I'm giving your file to your lawyer. He'll call down and talk to you, Mr. Ward.
All right, thank you very much.
You're welcome.
State of Ohio recalls Marcus Davis at the Lawrence County Jail, case number CRA 2613, A, B, and C.
So this is Mr. Holt's case?
Yes.
We need Mr. Holt in the courtroom.
Recall, he's on the phone with federal.
Okay, court, this will be recalled later in the docket.
We have several to recall to jail, Your Honor, but we're not ready for those.
Okay, we'll come back to some hearings here.
State of Ohio versus Meredith Holderby, case number CRA 25773. It's Mr. Stratton's case.
Need Mr. Stratton in the courtroom, please. Set for pretrial.
He's on his way.
Sorry, Your Honor, I was on the phone with the jail. We have a co-defendant on this case, too. What's your husband's name? Jeremy.
For a lawyer on that.
Yeah, Mr. Morford.
Jeremy
Maynard.
Maynard.
Yes.
Need Mr. Morford in the courtroom. He's probably on the phone with the jail.
Sometimes hard to get through there.
State of Ohio versus Jeremy Maynard, case number CRB 25774.
Scoot over a little bit. So I was thinking,
Morford.
maybe that following Friday. That would be the 16. Your Honor, I can make this short and sweet.
Okay.
We received discovery today in this case, the video and the paper discovery and the pictures. I believe Mr. Morford has them also. We would just like to reset this for another pretrial, possibly on the 16th. That's fine with the court.
Yes, that were 16th work for you, Mr. Morford?
Yes, Your Honor.
Okay. At the defendant's request, this case is continued to January the 16th for another pretrial. 10 o'clock.
What's your last name? Maynard.
Mr. Morford, did you get your discovery too?
I'm sorry,
Did you get your discovery?
yes.
All right, take a look at that, and then we're going to talk. Okay, all right. Actually, if you take a look at that tonight, we'll talk tomorrow. Okay, all right, good to go. All right, back to the jail.
State of Ohio versus Darrell Campbell, here at the court, case number CRB 25739.
Your Honor, Mr. Campbell, I believe, is on one of these video.
Chloe at UCMC.
Yes, I'm a social worker, I'm just gonna go get him and bring him into a room, has an intellectual disability, so it's like, while we were taking, just give me 1 moment.
Thank you.
And we have a letter to send forward.
I think the issue is going to be what we're going to do going forward.
Your Honor, I don't believe I have formally filed a suggestion of incompetency in this case. But my understanding is that in the meantime, since we've had this going on, he's actually been found incompetent by another court, which I think sort of forces my hand on that issue. I probably have to file that at this point now.
I have him here now.
All right, thank you very much.
Is Velma Hughes
Are
here?
you able to hear us?
Yes, we can. We can hear you.
I don't see
Hold on,
it.
my volume isn't working well.
Okay, we have Mr. Campbell's lawyers here, the prosecutors here, and there's a representative from the initial treatment agency he went to. I'd be willing to make a finding of his incompetency based on my observation, and that the other court has determined him to be incompetent. No objection.
I would not object to that, Your Honor.
We don't object, Your Honor.
Now the issue is what are we going to do?
I don't believe restoration is probably likely. I think this is a long-term issue. What's the nature of his placement where he is? Is he there under this court's order, or is he there?
He was placed there by Brown County, I believe. Was it Brown County?
Well, if he's...
But they decided to drop all the charges, so they're not going to maintain any connection.
I'm wondering though if the probate court in Brown County has picked this up in some way. Sometimes that happens.
I doubt it.
Okay. Well, I don't know the answer to this. I think this is a situation, I mean, I'm not qualified to say whether he's restorable, but I don't anticipate that were we to have him looked at, he would be found to be restorable. I think if the court's taking judicial notice of question of competence, also can take judicial notice of the question of restorability. And at that point, we're gonna have to figure out what we do.
Can we have some petition filed in our probate?
Oh, it's possible.
Who's going to do it, I guess, is the question, and who's going to, finding a guardian.
I I think there is, that's not something I would be able to do because of potential conflicts of interest. But my understanding is that there's a process for the state of Ohio to do that in a prosecution of this nature.
Or any interested party, not even interested, any party who has knowledge, including the court. And I'm not suggesting that Your Honor should necessarily have to do that either. Mr. Wilson from TPC Wellness is here, and that's how he got to Brown County, right? You have a facility in Mount Orab, and something happened there that caused him to go to UC. I don't know whether UC is willing to keep him for a while or what the status there is.
My understanding I had some conversations that they're not, that they want to get a resolution as of today, I believe. So the question is going to be what happens next and who's going to take custody of Mr. Campbell.
Well, I can tell you, Ms. Workman's not here, but she has been contacting me, and I believe she wants him home.
She has contacted you?
I believe so, yes.
Can we get in touch with her today? This is the mother, right?
Yes.
We've called her, and we've had experience with her in the past. It's very difficult for some reason to get a hold of her. And so we've reached out. You left the voicemails, right?
Friday.
Telling her to be here, and she's
And then
not here.
this morning again.
But I think it would be worthwhile, even if we issued a subpoena for her, to
So
be
the problem is
here.
going to be, I think he's going to be discharged from UC today. Where's he going to go? Is he just going to be?
Well, we're getting a shaking head on the video.
Oh, okay. I muted you, so let me unmute. I'm going to ask to unmute you. Yeah, you're muted. If you can hit your, there we go.
Yes. Yeah, we don't have any plans to discharge him at this time. With him having the CPO in place, he can't return home. We also don't have any way to get him back home right now with transportation. We're almost 3 hours away from where he lives.
Right.
So we've been trying to figure out how to get him back home. I did submit a referral for DDS in Morris County. So I think they were talking about trying to get some type of emergency guardianship of him.
So obviously, that's not going to happen today. Is he okay? Is he able to stay there until we resolve?
Yes, he's able to stay here.
Okay, good. I was under the impression that was not going to be the case. He wasn't going to have a place to stay. So we could put it on the docket for Friday and try. My understanding from defense counsel is perhaps his mother is willing to take him back.
Starting to wonder if maybe I'm thinking of a different individual, actually. I've got two kind of similar cases going on at once, and I think I may be confused on that. Who is the protective order in favor of in this case? Is this his uncle?
No, it's Velma Hughes. Velma Hughes, and there's another victim too. We have an intimidation charge, and the victim is Jennifer McClellan. I don't know if she's here.
And who is she?
Aunt.
Okay. Yeah, I think I may be confusing with another case. I apologize, Your Honor. I think the case I'm confusing it with is one that involves someone's sister. So I don't think that's actually.
This is his mother and his aunt.
Yes. So this is not the case that I was thinking of. I apologize. I don't think I've spoken to Ms. Workman in a while at this point.
And the prosecutor's attempted to contact her, and she's been unreachable.
Yes, and then not just this time, other times that we've had her for different reasons here.
Well, we've got to find a placement. It looks like it's going to need to be a long-term placement.
That would be my guess.
And what's even a possibility?
I don't know that until we get back the results of the assessment by DD Services that was discussed that we're going to even know that. And I don't know that assessment can be done until he's back in the area. So I don't. Can they do that where he is now? Okay, they can do that where he is. So that's a.
They're actually in the process of starting today.
Do you think Friday's enough time then, or would Monday be better? I'm here Monday as well. In fact, I actually already had this case on my calendar for Monday, and then saw it popped onto today. Maybe we can come back Monday and we'll have some kind of information from DD Services.
All right. Ma'am, if we continue this for a week to try to sort out his evaluation and placement, is he okay to stay there until that's the 12th of January? All right. Can you hear me?
Yes, sorry.
Did you hear?
You said January 12th.
Yeah, if we continue this a week to try to sort out what's going to happen locally with his evaluation, if there's some placement we can arrange here, is that something that your hospital can live with, him staying there for a week?
Yes.
Okay. So I'm going to put him back on the docket for January the 12th. And if someone can be available on January the 12th, we can try to, why don't we do this, so that you don't have to, because I think you've been sitting around waiting on it. Let's just set it for noon on January the 12th. I think it's more likely we can come right to you then. You don't have to sit waiting for us to.
That might give us a little time to follow up on make sure we have the report.
Are they doing the diagnostic assessment? Do you know specifically what type of testing they're needing?
I do not know that. Do we know what type, she's asking what kind of diagnostic testing they're going to be doing. Do you have any information on that?
Well, it sounds to me like it's more of a developmental disabilities finding that would then qualify him for services through that organization, which would, they provide people with places to live and assistance to live with them and, stay around the clock with them. And that might be exactly what he needs.
Well, I think that's what he needs.
So,
just from my observations and what I've seen.
Yeah, they call it a waiver. I don't know why they use the word waiver, but allowing him to receive these public funds to live off of and have a place to live and because he would be determined to be developmentally delayed or disabled.
Okay. Any other questions, ma'am?
No.
If you can be available, or whoever is taking your place, if you're not available, on next Monday, the 12th at noon, we'll come right to you then and do a hearing on this. Hopefully we'll have more information as to what's happening locally.
I don't know if anybody has my information that I can provide it.
Okay, so it'll probably be you then at the next hearing?
Yes, yeah. I've been working with him since he's been here.
Okay, very good. Thank you very much. January 12th at noon will be the next hearing.
Thank you.
Okay, thank you.
State of Ohio versus Evan Holmes. Here at the court, case number TRC 252696 A and B.
It's Mr. Steyer's case, pre-trial. Mr. Holmes, is that good report? Looks like he's making progress.
Your Honor, we're working on this matter. There is a discovery issue that's arisen in this, which is that sort of the nature of the chain of events here is such that the video by one or more officers of the Ohio Patrol were not connected to this incident because another incident was already being investigated when they came into contact with Mr. Holmes. And so the initial request for video didn't turn up a response, but then Mr. Hill has since figured out that video exists, but it's
In another case.
in another case, and he hasn't been able to get that yet, but I think he's working on that. And I'm going to need that video to complete my own investigation of the case. So, but Mr. Holmes is doing well in treatment, and I think that's something that Mr. Heald also wanted to see, and I think the court wanted to see. So I don't think we're out much by this, but I think we are going to need to keep going at least a little bit longer to get that video. And if Mr. Heald has an idea, like maybe how long it would take him to get the video and then get it to me and have a chance to look at it. So we're not necessarily in a huge rush to get back if the court's not.
Well, I think everything he said was correct, and it's just a matter of making sure that those troopers understand that it's, in this case, that we need the same video, or us being able to access the video from the other case. But anyway.
About the 23rd, is that enough, 2.5 weeks?
That would be fine with us.
Your Honor, I actually have a jury trial on the 23rd. It's actually unlikely to go forward, so we could set the case, but I can't tell you 100% that I'll be here. I'd say I'm about 80% sure I'll be able to be here that day, but as of right now, technically I have a jury trial scheduled.
All right, let's do that, and then we can change it.
Okay.
January 23rd will be the next hearing.
Thank you, Your Honor.
Thank you.
State of Ohio versus Garrett Lee Hosey, for report, case number CRP 546.
Mr. Stires' case, pre-trial.
What are we going to do? Just a second.
See, my mom was going through a divorce whenever I got to a party. So, yeah,
Don't talk about that in here. It's okay, the microphones.
This is Garrett Hosey. Hey, Luke.
Do you have a written report with you by any chance?
A written report from
From Path?
my next appointment is the 15th, but I brought one already.
Okay. Tell you what we like to do is come back with one more.
That's fine.
Written report. Okay. I think Mr. Heald would like to see us come back one more time on this. We'd like to get a written report from Path. Mr. Hosey's indicating his next appointment is on the 15th, so if we could maybe come back sometime after that. I'm available on the 16th, might be a little quick. We could go to the 23rd again with the same proviso we made before. That would give them time to have the report written and either sent directly to the court or given to Mr. Hosey.
Where's the report? The same thing I brought?
Yeah, we want one up to date.
Okay, yes, medicine. Okay.
Yeah.
January 23rd.
Thank you.
Next hearing.
Yes, so write that down here so you have it.
Okay, 23rd of January.
Yes.
State of Ohio versus Megan Lynn, case number CRB 25661 A and B.
Mr. Stires' case for pre-trial.
Just one second, Your Honor, I just signed these entries for Mr. Heald. Mr. Heald has provided us with a written estimate of damages that were allegedly caused in this case in connection to the case. I provided a set of that information to Ms. Lynn. She is agreeable to, and the state has indicated that the victim has said that their interest in this is primarily getting the restitution, which is $2,700 and some dollars. Let me get the exact amount so that we can put that into so we can actually run that through the court. Its total is $2,765.03, and it would be obviously payable through the court for the benefit of Robert Bocook, B-O-C-O-O-K. And my understanding that Mr. Heald has stated that should that restitution be paid, they would be interested, or they would be willing to consider dismissing the case if there's no further problems. This has been going on since October 16th, so we're about where our 90-day continuance would have taken us anyway. We're not quite there. But Ms. Lynn says she needs about another 30 days to get the money together. So what I'd like to do at this time would be to continue the case out for about 30 days from now. That'll take us outside the 90-day window we normally look for on these. Does Monday or Friday matter to you? The 2nd, 6th, 9th, and 13th are all free for me. So if there's a day among those that's best for the court of February.
I'll do the 9th.
Okay.
The 9th is Monday.
Okay, so write that down. And come back and look at the issue there. And I'm going to advise, and I'm assuming that an order is being entered to allow that to be paid into the court at this point. So if you get that money, you can actually just come to the court and make the payment. And then we can come in here and say, oh, it's already been paid, we're ready to
Court
go.
will accept $2,765.80 for the benefit of Robert Bocook. Ms. Lynn, you can pay that prior to the case being resolved.
Thank you, Your Honor.
Next hearing is February 9th.
Pretty good.
10 o'clock.
State of Ohio versus Robert Stickler, case number TRC 252722 A and B, TRC 252303 A and B.
Your Honor, this is a urine screen case, and Mr. Heald was checking earlier whether he had results, but I don't think you had an answer on that quite yet.
We did. As a matter of fact, I've already read it.
Okay. Okay, well, results in, I'd like to file discovery on this matter, take a look at any side issues we have, and come back from there if we could. So, if we could come back on the 9th on this one as well, that would give me time to.
There's a time waiver.
And there, yes, obviously time waiver, Your Honor.
February 9th, the defendant's request to be the next pretrial on both matters.
I'll take a closer look at this.
I guess, can you hear him? Yeah. Yeah.
Thank you.
State of Ohio recalls Kenneth Malone at the Lawrence County Jail, case number CRA 1814, CRB 1815 A and B, CRB 162229. Brandon Stratton on that.
This is Mr. Stratton's case, and we were coming back after Mr. Stratton met with Mr. Malone and got issues of bond and hearings and that sort of thing to resolve.
Your Honor, the state offered Mr. Malone to plead to all the charges and reduce the felony to a misdemeanor. Mr. Malone will do that, plead guilty to all the charges. The state's recommendation is going to be suspended time, except for 10 days. He has credit for 2.
Credit for 2?
Yes.
Is that correct, Mr. Mullen? Your audio's turned off. Your lips are moving, but nothing's coming through, so it's probably turned off with the headset. Usually is what happens. You'll have to turn it on. Okay, try it now. It's still off. Not getting anything. Try the headset. Usually there's a switch on that, but it's just turned off. There we go. Now we can hear it.
Now I can't hear you very well.
Okay. All right. I hadn't said anything. Can you hear me now, Mr. Mullen?
Yes, sir.
Okay.
Yes, I hear you.
Did you hear what I just said? Mr.
No, I didn't.
Okay. So, Your Honor, Mr. Malone's going to plead to all the charges. Understand the state's going to reduce the felony to a misdemeanor. The state is going to ask for suspended time on everything except for 10 days in jail. He has credit for 2.
Do you agree with what your attorney is representing to the court, Mr. Mullen?
Yes, sir.
You have a right to make a statement to the court if you want. Do you have anything you want to say?
I just want to say thank you.
Okay. So on
I'm sorry I didn't all get this far.
1814 is amended to an M1 possession rather than an F5 possession.
Yes.
So that's 1814. And on it, I'll impose a $200 fine, or the court costs be paid, 10 days in jail with credit for 2. He's to serve 8 more days. Review hearing July 27th. Then there's 1815. 1815. That's actually should be that rather than resisting, it should be 29-21-331, not 331 is the correct revised code number. Yeah. But we're amending it, and it's an M1. And I'll just impose a $100 fine on that. Same review hearing. So I think it's all the same day, so that just one court class. Deer Parks case.
What is it, sir?
You got the one that they were saying you had 16 pair of antlers. I don't understand unless you're going to grind them up and eat them. If somehow it does you some good, I don't get it.
I don't get it either.
Josh gets it, but I don't get it.
I'm guessing that the state confiscated those, and even though it's been, whatever, 8 years ago, they may have them in a box somewhere and may want an order that they be forfeited to the state, just in case. So we
Okay.
asked for that.
I'll order they be forfeited to the state, I won't even put a fine on that.
Thank you, sir.
You can walk along, you probably picked them up out on the bypass, didn't you?
There's a deer getting hit at Drew Clark's every other week, I just cut them off and take them.
Everybody else
I
is
didn't
all
think I was doing nothing wrong.
camoed up and geared up and gunned up, and I'm trying to not kill a deer, because they want to jump in front of my car all the time.
Oh, I'm sorry.
You don't have to be sorry, but obviously I'm not a deer hunter, if you can't tell. So I don't really get it.
I have deer hunted, but I ain't never killed that many.
Okay, so I order that they be, if they're still around, they be forfeited to the state, and I won't even impose a fine.
So here's my wife and my baby.
Okay.
You said my baby just walked into the courtroom, Mr. Gabbard.
I saw that. Okay, on the C case, that was the polluting the stream, I'll impose a $50 fine.
If I miss something, I just can't hardly hear you.
Now he's got a bunch of other traffic, old traffic. We're resolving these two, right?
Yeah,
He had appeared initially, but then failed to appear. One was like a DUS, he was given time probably to get his license.
Yeah, we're going to resolve everything today, yes.
That's 16/22/29, $50 fine, and court costs, because that was a different time, it's not the same time. $1634.87, $50 fine on the driving or suspension, I'll dismiss the fictitious registration. And 16/15/44, he'd already been sentenced, and I'll complete, he paid the fine, but he didn't do his community service. I'll complete it by the jail time he's done.
Okay.
Okay, so you're gonna get out of jail today?
No.
What am I doing?
No, I'm sorry, no, you got 8 more days.
8 more days.
I thought so. I thought so.
8 more days, and then you'll get out.
1822.
Okay, thank you, sir.
1822.
So,
Let's dismiss
next
it.
coming.
Give me just a second, I need to catch up.
Okay. Okay, that's all, Mr. Moore.
What is it, sir?
That's all. You're finished.
I'm finished?
Yes,
Thank you, sir.
You are.
Thank you.
Hey, Sean. This guy, is it Scott, you say? Does he have pending cases, or they?
I'm not sure if I can get this one thing or back here or not. I see announcement, but.
His right play just needs to be sent.
We're not to your case yet. We're still cleaning up some things on the last case, so we'll get to you in just a
Do you
minute.
have notes on that? You would say. It's not- it's not-
And the fictitious registration, do you remember?
Dismiss.
Says it. That's it.
State of Ohio versus Brandon Scragg, case number CRB 21524, TRC 2715, and Marcus Davis is on deck.
Mr. Stratton's case.
So, Your Honor, he's pled to both these cases. I think on the one, he just owes maybe about $655. And then he's already pled to the theft case, so he just needs to be sentenced on that. Last time we were here, he was inpatient at LCR, left LCR. But he now is currently outpatient, he said, at KDMC, correct?
Yes, sir.
And he's willing to take a test at the jail if you want to screen him, so.
I think that's a good idea. Let's have him do it. I want you to do a urine test there at the jail, see where we are.
Yes, sir.
Then I'll have you back after I do that, because the last one I did, and it's been a while, but in January of '24, when you were here, you tested for some stuff. So let's see what you test for now.
You'll test for Suboxone, is that correct?
Yes, if it's still in my system. Like I was telling you earlier, I've been tapering myself off of it because I don't feel that I need it anymore. So that should be all, that and just marijuana would be the only things that should be in my system.
All right.
Okay, go do your urine screen.
Thank you.
The State of Ohio recalls Marcus Davis at the Lawrence County Jail, case number CRA 2613, A, B, and C. It's Mr. Holt's case, and I'm not sure exactly where he is.
We'll ask him to call him.
Yeah, that's fine.
Where is that?
And did he ask for it to be recalled? He said for this Friday. Did he ask for it to be recalled?
This jail thought he did, and there was ones who told him.
Okay, well, Mr. Holt's not here, so it's already set for the 9th, we'll just keep it on the 9th.
We should be finished at the Lawrence County Jail.
We're finished at the jail.
State of Ohio versus Sybil Crowder, case number CRB 25759.
Mr. Morford's case for pre-trial.
Well, it's a theft charge, so I think what the judge generally does.
Do you want to decide what to do with this?
Yeah,
Okay.
Judge, we'd like to continue this so she could come in and we revisit DVD together before she decides. We could, well, I've got a jury trial that starts tomorrow, so if you could give me like the latter part of next week or Monday, well, latter part of the week would be better.
12th would be, well, you said your jury trial starts next Monday or this week?
Tomorrow.
Tomorrow. You're okay the 12th?
Yes, Your Honor.
Let's do it then, January 12th. Pre-trial, January 12th, 10 o'clock.
State of Ohio versus Corey Easton, case number CRA 2518, CRB 25811, CRB 24-222.
Mr. Morford's case set for proof trial and preliminary hearing today. Corey Easton, I don't see here.
I didn't see her on the jail list, Your Honor.
She's not. She has no log on. Okay, I'll issue a warrant for failure to appear.
State of Ohio versus Jimmy Clark, case number CRA 25-823.
Yeah, this was the Rule 4 to Pike County. He's picked up Pike County for you, so in case you're...
State of Ohio versus Christopher McAllister, case number CRA 2720, CRB 2721, CRB 18596.
Chris? So, Your Honor, last time we were here on the 15th of December, Mr. McAllister was waiting on his medical card. He now has that, and he now has a schedule with OVP coming up on the 9th.
Mr. Neal?
We're okay with that.
So, Your Honor, I asked that we just reset it, see how he does at OVP, maybe first part of February.
The second?
Second's bad. Yeah.
6th?
Yeah, 6th work.
February 6th, the next hearing.
Just make sure we get a letter from OVP. Okay.
State of Ohio versus Crystal Winton, case number CRA 25296, CRB 25297.
Your Honor, Ms. Minton came to the office right after she was here. Well, I wouldn't say right after, but she shut the office and she was clean, but she's not had any contact with us for services at all.
Okay. This is a felony. Say, well, warrant from here or signature
We'd like to have a warrant from you, Your Honor.
We'll try to reach out as well.
Okay, be a warrant issued for not doing treatment and not appearing for a hearing today.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Christopher Young, case number TRC 212199, A, B, C, and D. Your Honor, this was originally set for trial at noon, but I believe there's some sort of resolution.
Your Honor, there's not a resolution to this case. Mr. Young contacted me this weekend, said he was unable to make this court date. Told him it's set for trial. Told him if he's unable to make it, come as come to the court as soon as possible, so he's not here today.
Okay, so he's got 7 days to get in before Mark will.
Thank you, Your Honor.
State of Ohio versus Richard Sundline, case number CRA 24591.
Mr. Smith's case and Mr. Sutherland is on teleconference.
Okay.
Except for counsel consent.
Pretty good. Yeah.
Okay, well, it says he's being compliant and is screened for what he needs to screen for.
That's correct, Your Honor. He's doing well.
Okay. A month out.
Yes, sir, I'm here the 6th, 9th, or 13th of February.
Let's do the 9th, February 9th. The preliminary hearing. Okay, Mr. Sutherland, good job, keep it up. See you in a month.
State of Ohio recalls Brandon Stride of Orange County Jail. Case number CRB 21-524, DRC 2715.
Have you seen the results?
I have.
Okay. Okay, so I think we're back to where we were before. Not much has changed.
Honestly, sir, don't know how it didn't, marijuana did not show up on the test, but cocaine did. Because on New Year, last time that I partied, and all I did was I smoked and I drank, and I don't even understand. I truly don't. It makes no sense to me. Now, it would make sense if maybe there was cocaine in the marijuana, but for there to be no marijuana at all, I'm very baffled.
Your Honor, I guess,
Well, but my disposition would be, me just gonna give him jail time, let him serve some jail time, and be done with it. If he doesn't wanna go back to treatment. That's my choice, not his, because the one he's going to is not working.
yes. So it's either the judge's choice of treatment or just straight sentence you to jail.
How much jail time would it be? Just curious.
That's up to the judge.
We haven't decided that yet.
Treatment, I suppose.
Now the question is, will anybody have it?
Well, I've heard good things about Mended Reeds. I used to work with some fellows that went to Mended Reeds at Two-Year Biscuit World, and they said it was a really good place.
Well, they're not here today.
ODP, I've been there before, and.
Well, I'm gonna send you to RRS if they'll have you.
What is it?
A place called RRS. They're gonna call down and talk to you. How long have you been in jail now?
Since Late Friday night.
Do you want to recall this, Your Honor, or do you just want to set a bond and order him to treatment?
Let's go ahead and can you, Jeremy, do an evaluation? I'm gonna have somebody call and talk to you, and then we'll have you back after you do the assessment.
Yes, Your Honor.
State of Ohio versus Michael T. Davis here at the court. Case number CRA 25-347 A and B, CRB 25-348 A and B.
Mr. Smith's case, we'll come in here and pre-trial.
Judge, he indicates he's graduating the residential part of his treatment. He's still doing outpatient with, who are you with?
OVP.
OVP.
Yeah. Is, who's there from OVP? Okay. I see teleconference saying there's OVP, but nobody's on the screen.
Which OVP you go to?
One out in Louisa, Kentucky.
Okay, Mingo County.
Way out there, Wayne. Kind of.
Yeah, he goes to the Louisa branch, Judge. He's out kind of Wayne, Mingo County area.
Oh, okay.
So that might be, well, I don't know if they would know his progress or not. Are you making your meetings? Do what you're
Yeah, I'm
supposed to.
doing everything they're asking out of me.
Well, this is a felony possession from this past summer, so we need to get a report. I don't have a report since, last one I got was November 17th.
If we come back one more time and I'll reach out, have a report sent, then hopefully we can get rid of it. I don't mind doing that.
February 9th?
Yes, sir, I'm here.
February 9th will be the next hearing.
What would I need to do on my end?
Just make sure that you've signed a release so they can send a report to me. I can go to the court. Or you can bring them with you.
Okay.
It's got to be current, yeah, just to show you've done what you're supposed to do.
State of Ohio
Nine.
versus Stephanie Stevenson.
At 10 o'clock.
Here. Case number CRA 25-821. Stephanie Stevenson.
Mr. Smith's case.
Yes, Judge, I thought she was at OVP.
She's on telecom.
Oh, that is, okay.
There she is.
I've not met her yet. Hello, Stephanie.
All right, Ms. Stevenson is at OVP. This is her first teleconference hearing. Mr. Smith's her lawyer. She's got, oh, it's a Tampa. Oh, I remember, this is the one, the car. So how are things going at OVP? How are things going there? Good. And you're scheduled to finish up when?
I'm only using outpatients.
When's your date to finish?
I got here the 24th, I think they have graduations on Friday, so I graduated the 23rd.
I'm here the 23rd or 26th.
Right.
Either, whichever you prefer, Judge.
Okay, let's, before you graduate, let's come back then on the 23rd of January. You can appear by teleconference. looks like today.
We'll come back on the 23rd
23rd.
to see you. I still stay here, right?
Yeah, you stay there.
Okay.
Unless they decide to bring you, if they bring you in person, that's.
No, I'm good, I'm good.
All right, January 23rd is your next hearing.
All right, thank you. On Zoom, we do one here, are we doing it in person or on Zoom?
Either one.
Either one, okay. What?
10
What
o'clock,
time?
10 a.m.
8 a.m. Thank you. Thank you. You said that's how you do it.
It's not just a straight dismissal.
State of Ohio versus Amy Van Zandt, case number CRA 25-458, A and B, CRC 25-830, CRG 25-456.
This is Mr. Smith's case set for preliminary hearings and pre-trial.
Are you doing good tree? Are you still over here? Yeah. He was not court. He's court. Oh, he's there. He was out of town. She's still over here. Okay. Judge, she is still with OBP. Her counselor, whose name is Court, did not send a report to the court. So, okay, well, I'm not throwing him under the bus, but I'm just saying we don't have a report today, so I think we're going to have to come back. If I understand, there's still a shoplifting out there. I do have the video. I brought my laptop last time. Unfortunately, Ms. Van Sant couldn't be here, so she hasn't seen it yet.
So she's outpatient then?
She is, and we'll need a report from court. For court.
Yeah, I'll see you tomorrow at 1:45.
Okay, she's going to see me tomorrow at 1:45, Judge, and she will make sure we have that on next hearing. I assume she's doing well, but we want to confirm.
Are you available before the 9th?
I'm the 9th, and I've got trials. I go from the 9th of January to the 23rd and 26th.
Let's do, you say you're available 23rd?
I am, Judge.
Let's do that.
Okay.
January 23rd will be the next one.
Make sure you get some reports. Okay. Sure will. Thank you.
State of Ohio versus Chester Burton Jr., case number CRA 25-798, CRB 25-799. Chester Burton.
I'm here, Judge.
All right, this is Mr. Stiers' case, Mr. Burton. Is that OVP?
I misunderstood the first name, he said different Burton, sorry about that.
Chester Burton.
Yeah. Take a quick look at this one. He's an OVP. We have a F5 fentanyl related compound on this and a Walmart theft. Did OVP send a written report?
I don't have it.
Okay.
Do you need something from OVP? She said no, if you'd like.
Okay, yeah, when he finishes there, he's gonna go to RRS. I think there was a issue of detox. So I don't know, do you have any idea, like a word on whether they're gonna send him to you?
Yeah, there's a day, I think it's on the 21st of this month.
Okay, so he's expected to move over on the 21st to OVP.
RRS.
I'm done, from OVP to RRS, I'm sorry about that, Your Honor. So, I think it might be worth coming back, maybe a little ahead of that. I'll be here on the 9th, no, actually I can't be here on the 20th, I've got court in another county. I'll be here the 23rd, we could come back a couple days after the expected transfer and kind of see where things are.
All right, Mr. Burton, do you agree that you're supposed to transition over to RRS after you finish at OVP?
Yes, sir, I agree with that. But my graduation from the ODP thing here is on the 16th, but I'll be on the 19th, and I don't trust myself yet to go. January.
They'll accept you on the 16th.
No, we're just picking a date to come back here and see where things are. Now, you'll go directly from one provider to the other.
Right, but I said a second ago that I will be transported on the 21st. I'm scheduled to leave here on the 19th.
We just had the wrong day.
Oh, okay, all right.
We won't be there whatever day you get.
No, I'm glad you did, but whatever day it works out, the two providers will be in communication, they'll take care of that. We're just getting a date. We're just want a date where you've had a couple days to get adjusted to the new place and then come in here and kind of see where things are.
Yes, sir. I appreciate that.
Okay, so that'll be January 23rd.
Thank you.
All right, thank you, guys.
You are.
State of Ohio versus Caleb Ham, case number CRA 25809, CRB 24765.
Mr. Stiers' case, preliminary hearing, pre-trial.
Can I have just a moment to speak to Mr. Ham? I wasn't here the day I was appointed. I didn't realize he was here, so I apologize.
I was in jail when I got you appointed.
Yeah. They've got an offer here today, got an F4%, an F4, that's constant priors. They are offering that if you would plead to a misdemeanor level, they would recommend suspended jail time. Otherwise, they're going to take the felony to the grand jury.
So I wouldn't get jail.
Well, you get suspended jail time. So if you don't, you're going to be ordered to stay away from her. And if you don't keep up with that order,
I'd be ordered to stay away from her.
Yes.
That's my wife. We're here together. She
Hang
had
on
the
just
protective
a
order
second.
dropped.
Okay, well, I wasn't aware of that.
Yeah,
Okay. You wouldn't be ordered to stay away from her then, just no further problems.
And it would be from a felony to a misdemeanor?
Yes. Otherwise, you're fighting a misdemeanor, it's felony.
Do I have time to come back for that? Or
Let me ask a question. Hang on. Your Honor, I've presented him with an offer for the safety, he'd like an opportunity to discuss that with his family and make a decision. So we're willing to waive time constraints to continue this a brief period. We would like to come back fairly quickly, and he recognizes that the felony will remain pending while this is going on, so the decision doesn't necessarily take care of the felony, but it does give him the opportunity to think. I'm going to be back here on the 12th.
12th's a pretty light docket.
Let's go ahead and put him onto the 12th then, Your Honor.
January 12th.
I need to talk to you.
Okay, and they're going to talk about my KPS.
Don't leave, I need to talk to you.
Oh, you have a case from another state? Or
No, for here, through there's a protective order KPS.
He's saying there's a case on a protective order case. I have two matters here.
I don't think there was one issue.
I know that you released me on the KPS on the OR bond for both charges, and you said you were putting in a not guilty plea for that KPS, so I don't know where that was going or how that was going.
Okay, I think what he may be talking about is I got CRB 24765 attached. It was not.
Got dropped in March. Oh, sorry.
Second. 24765, is that an active case?
It is.
But the bond that's posted is covering both matters?
24,765.
That's violation of protection. It's an old case from November of 24.
Okay.
Actually, I don't even see a bond on that. The bond is on the other case.
I would ask that the bond cover both matters then, and if there is a capias on the older matter, that it be withdrawn.
Yes. It should be withdrawn. 24,765, if there's a warrant on that, it should be withdrawn.
Yeah, we'll try to see where.
Right. Again, don't leave, I need to talk to you.
Yes, sir.
I don't think there was any kind of, I don't see a protection order issued on either case.
Okay.
Is Lindsay Pennington here? Is that?
Yeah, she's here, Your Honor.
You want to come up and talk to the prosecutor? Excuse me, talk to the prosecutor, please.
Oh, she's on this new pass.
Yeah.
But, she's not on
I saw the protective order thing, I thought it was the same case, I'm sorry. They're separate matters, this is, it's actually different individuals. What is the fact that I'm sorry. And you sign your forms, the court another day, 23rd of January. Does it say you get it for counsel? So we can tell the judge that if you don't have protection. Okay.
Is it the 23rd or the 12th? I think it's the 12th.
Oh, the day he wants me to come back?
Make sure. Your Honor, and this is Lindsay Pennington, and I don't think she wants a protection order.
Is that correct, ma'am?
Correct.
There was another person on the complaint though, wasn't there, in addition to her? Looks like, Raymond Jenkins. Well, I think that's just the wrong name there.
Yes, we need to move to amend
Sorry,
that, Your Honor.
Dan.
Oh, I see what you're saying, yeah.
Or it should be amended to Caleb Ham there, right?
Yes.
All right. So, ma'am, at your request, there's no order for him to stay away from you. That's what you want.
Yeah, I want to talk to you. I'll come and what's going on after. I've got 2 or 3 cases to be called. All right, I think that's all for now then. We're going to set both matters for the 12th. And I'm going to discuss with Mr. Ham what's being offered and give a little better chance to explain what's happening to him.
Okay. 1 week from today is next year.
Thank you.
Thank you.
Okay.
I'll see you next time. I'm good. I'll talk to you.
Yeah, that's fine.
State of Ohio versus Howard Lane, case number CRA 25101.
Just call me if there's any issues. Okay, thank you. Yeah, I got one. Okay, thanks.
Okay. From what I'm reading in the report, there's some progress, but he also needs to be more fully engaged and find a job. Those are the 2 things.
Yeah, I've been looking, just with my record, it's hard. There's no transportation available there, and we can only get jobs within walking distance, so it's tough.
Okay.
He has as well, and he has, since we've been here last, completed his, right there, it's to let me get paid on your case, you can't afford counsel. He has completed the terms of his community control probation with Iron Municipal Court. He was on that for a different case. That's wrapped up, he's completed that successfully and continues on with this matter. So I think what we want to do probably is look to come back on a time frame that the court deems appropriate, Your Honor. I don't know what sort of a time frame you'd like on this.
Well, we gave him 2 months the last time, didn't we?
Yeah.
Almost 2 months.
Yeah.
What's the prognosis in terms of him finishing up with the council?
I mean, ultimately, our next step Your Honor, is to see somebody gain independent living and employment.
Will you be going back to Ironton when you finish this all up, or what's your plan?
Yeah, yeah.
Okay.
Yeah, I'm in transitional in Ironton, actually.
Oh, okay, you're in
Yeah,
Ironton.
yeah, I'm in Ironton. Yeah, I've been in transitional living for almost 4 months now.
And how much time do you have sober, clean sober time?
Over 6.
Okay.
Yeah, I've been in,
You can try Superior Marine if you're willing to work.
yeah, I
People will
mean,
give you the contact information.
well, I have no transportation, that's the problem.
South Point. From Ironton to South Point. Okay, let's come back, toward the end of February?
Toward the end of February, Your Honor, I have the 20th or the 27th available.
Let's do the 27th.
Thank you.
February 27th will be the next hearing.
Good job.
Thank you, Your Honor.
You're welcome.
Wait, and I'll come talk to you. Okay. Yeah, I've got one or two more I'm going to talk to.
State of Ohio versus April Hackworth, case number CRA 25676.
Mr. Morford's case, under hearing.
What's your? Office last time I was here to take a drug test. So I need to do that.
What's your? The last name?
Yeah.
So this is still on the preliminary hearing docket, but I don't have any reports that she's getting treatment. I'm not sure what the plan is here.
Judge, when we left here, you had ordered her to do a drug test, and she didn't know where to go to get it, didn't stop to ask anybody, and that has not been done.
What's his statement?
Well, I think that it would be appropriate if she were to do a drug screen today.
She wanted to do one here today?
Yes, Judge.
Come back Friday if necessary.
Well,
Or whatever.
are you willing to do a drug test today?
Yeah.
Okay.
Go to
I just-
the probation office.
Take it out.
Now, you go to the left hand,
All right.
and we'll call it back.
State of Ohio versus Alan Kennard, case number PRC 252731A and D, CRB 25686.
I see you on the file.
I think I brought it back. Did I not bring it back? Maybe I didn't bring it back.
It's right here.
Shoot. I didn't get it. Let me see here.
Well, I mean, you gave it to me.
No, I brought back here. Let's see, let's see, let's see.
All right, so Mr. Kennard is here today. I have it down as a trial today, is that right?
Yes, Your Honor.
Okay, we having a trial?
I believe so.
Okay. We've got other stuff that we can do before, so we'll recall it when we get the other things completed.
Okay.
State of Ohio versus Brandon Scragg, case number CRB 21524, PRC 2715, with Lawrence County Jail.
RRS is able to take him, all right,
Okay.
so
I'll order him released to RRS with a $2,500 OR bond. And next hearing, he's next for inpatient.
yes,
Let's say, are you here the 12th?
that's a bad day.
Okay. 16th.
Yes, that'll work.
Next hearing will be the 16th. Make sure he's there.
All right, thank you, Your Honor.
You're welcome.
When, may I ask a question? When are they coming to get you?
Today.
Today.
Today? Okay, thank you so much, I appreciate it, Your Honor.
Unless you want to spend another night at the jail.
I don't think so.
You want to spend another night at the jail?
No, I do not.
Okay, so they're coming today.
Thank you.
You are.
Your Honor, what was that bond again?
2,500. And he's His next hearing is the 16th.
State of Ohio versus Joshua Garbison, case number TRC 24-746 A and B. Originally, you scheduled a report for jail here today, Your Honor. I understand there's something else that wants to talk to you about.
I can barely hear you, I'm sorry.
Set for a hearing today,
You were set to report for jail today.
reporting to jail. Okay, this is the one, where's Mr. Holt? Is he?
I'm not sure, I tried making contact to him,
Your Honor, if I may, Your Honor, Mr. Holt was called onto a Zoom call by the federal court. He's actually here, he's just back in Mr. James's office.
Okay. We'll
Stuck
recall
on the line.
We'll recall, your attorney's here, so we'll recall when he's available.
State of Ohio versus Michaelan Wells, case number CRB 24-657 A and B.
It's Mr. Smith's case.
Your Honor, I called the administrator, Lawrence County Children's Services, and asked her earlier today how Michaelan and her spouse were doing in their children's services case. And I've been told that there's been a little bit of a setback, that they extended the home visits of the children, and they went for a checkup to see how things were going, and things weren't exactly as good as they would hope that they would be. And so they're still working on their case plan. And so from that standpoint, we're not satisfied with that Michaelan has reached the expected outcome in the children's services case yet, but the case is still open.
Well, the Bethesda report says she's not compliant with screens. I'm not sure, what does that mean?
Either
Not doing them, or?
she missed a screen.
Okay. Well, it sounds like we still have more work to do then.
We do judge the 6th, 9th, or 13th of February, or I've got a couple dates in late January.
What did you say, 6/9?
6, 9, or 13 of February.
Okay, I'm looking at the wrong month, that's why this don't make any sense. Let's do the 13th. Next one is February 13th.
State of Ohio versus Justin Melcher, case number CRA 25-333 A and B, TRC 25-1265.
And I have this is Mr. Steyer's case. That looks like he's being compliant.
Yeah, I think we have a positive report there, Your Honor. Definitely showing progress through the programming, so happy with that, Your Honor. At this point, kind of look at where we want to go on this. This is we're here for sentencing on an OVI, and I think there is an F5 possession that is pending, sort of, I think with the idea that depending on how he does, may look at a dismissal of that. But the OVI, I believe he pled guilty to on a previous occasion.
I think it was amended to physical control, is what my notes were.
Yeah, that's correct, Your Honor. So we saw the sentencing on that, but the preliminary hearing is still pending on the other because it hasn't been dealt with yet.
So we're just, we're about 7 months into his treatment.
Yes.
I mean, 7 months is a long time when you're doing it, but 7 months in the scheme of things of somebody's sobriety is not very long, really. So I prefer to see him have more recovery time before we cut him loose.
What sort of a time frame would you like to look at to come back
Come
here?
back in a couple months, maybe.
Couple months, early March, I think. We said something earlier on the 9th. Could we go with that date, Your Honor?
Yes.
Okay, so March 9th.
March the 9th will be the next one. We'll look then to wrap it up.
Thank you.
Good job, man.
Thank you.
Thank you.
Thank you.
You're welcome.
State of Ohio versus Michael Clay. Case number CRB 2010-23, CRB 18-796, CRB 18-251.
This is Mr. Sires' case. Wasn't it?
It's coming.
Yeah.
Ever since he left our inpatient, outpatient, he showed up.
You might recall we had this case a week or two ago, actually, excuse me, about 2 weeks ago. At that time, Mr. Clay had completed inpatient treatment. It was scheduled to start outpatient, did not appear here. I asked to continue the matter so that maybe through RRS we could connect and maybe get him the new court date. And I think RRS has updated you on that. That didn't really work out the way we hoped it would.
Yeah, so, these are all, yes, these are misdemeanors, so.
And they're all set for sentencing, Your Honor, so there's been guilty pleas on everything. We're just following it through sentencing.
Yeah, it's disappointing. I thought maybe he was with all of his issues are severe. I mean, he's had a severe problem, and that's what the assessor said. He had severe opioid use disorder, cannabis use disorder, cocaine use disorder, and alcohol use disorder. So he just didn't follow up once he got out of inpatient. So would be a warrants issue.
Thank you, Your Honor.
Thank you.
State of Ohio recalls April Hackworth, case number CRA 25676.
Okay, it's an acceptable screen. This is Mr. Morford's case. What's the state want to do with this case?
Yeah.
It's current script, and it gets filled out every month. Sometimes it would, she had it her first.
Yeah, he's got a case here right now. Let's see. So, Your Honor, Mr. Morford has presented me with a report that shows that another individual has the prescription. I don't know.
Her boyfriend, Your Honor.
and the boyfriend is somebody who actually has a case before the court right now, Robert Stickler. But she says that it wasn't her pill. And this charge would be a misdemeanor, but for she had another drug charge in the past. She tested clean today. I think that probably under the circumstances, we should just go ahead and nollie the charge.
Okay, that means, they're gonna dismiss it with the right to refile if something else comes up, but at this point, it's gonna be dismissed.
Good to go. It's done. It's done. It's over.
Well,
State of Ohio recalls Joshua Garbison, case number TRC 24746, A and B.
all right, so this is Mr. Holt's case, there's been a previous plea, this was a second offense, I believe, and the whole, we one of the ones where we sentenced with 10 days as the minimum requirement under Ohio law on the second offense, but there was an agreement that, I believe, that if Mr. Garbison went to treatment and was really successful at that, then that maybe the jail sentence wouldn't be imposed. And that's what the issue is here.
May I approach?
Not that impressed with what he's turned in so far, yes.
Do you have the Burrell bid here?
No, I don't think I really did.
Mr. Garbison's been through, at least I know more of, 3 different providers.
Correct.
There was issues because he does travel the country for work. I believe initially you had someone from California that you were
Correct.
paying out of pocket for. It was, I thought was incredibly expensive.
The latest one I completed, there was the initial provider, she got fired. Started up my new guy in October, and it missed 1 session, and we completed it within 2 months. And that is state recognized in Missouri.
Do the Missouri driver thing. Is that the Missouri driver thing?
That's still
Missouri driver thing.
Missouri driver.
Is that the program?
Missouri.
And I believe that's a program that's recognized by the state of Missouri, because Mr. Garbison does have a CDL, and he has to take that, or something that's accredited to actually be able to get his CDL reinstated. And he did also attend AA in different, and my last time speaking with you, you had attended AA various points.
Yes.
Now, none of that had been submitted to the court up to this point. The one thing I do note, the one report said he still has additional sessions to complete. It's not completed yet.
I cannot, no.
He can't even hear me.
I'm hard of hearing, sir. I apologize.
He couldn't hear him speaking.
One report says you still had some sessions to go to complete.
It should have been the very cover one, showed a course of completion. There was one of the back 2 pages were update progress reports. I'd asked to present to you whenever I had review hearing, if I hadn't had it completed by then. But one of those should have been a completion or graduation.
Okay, I was looking at the one, I guess there was something in the file that said this. It says he
had a bunch of check marks.
12 to 15 education group left to do. It's recommended he continue to engage in next level care, attending outpatient services until SATOP is complete. I don't know what that stands for. That was December
This one
the
should be
8th.
completion.
It's the STO.
So that was not quite a month ago.
Same top, it's a substance abuse traffic offender program. That's what they call it there in Missouri. I think it's recognized here as a driver intervention program too, DIP possibly. And I think that's interchangeable. I am his first client also, so there was a little bit of,
Yeah, I see it.
I was different, I didn't plan on flying either today or after.
Where'd you come from?
Missouri.
You're from Missouri.
Well, this is unusual because, okay, the December 12th one, let me just read the December 8th and then read December 12th, and they're very inconsistent. And these are from the same person. To him it may concern, this is December 8th, 25. Joshua Garbison entered outpatient treatment at Burrell Behavioral Phoenix Clinic on May 30th, 25. Joshua's worked hard on understanding the addictive cycle, learning tools necessary to sustain recovery. Joshua has been on time to all scheduled individual sessions and has finished the 10 individual sessions required. He has a total of 12 to 15 group education left to do. It is recommended that Joshua continue to engage in the next level of care, attending outpatient service until SATOP is completed. That's signed by Michael, well, it's not actually signed, but it's typed in Michael Booster. But then 4 days later, December 12th, to whom it may concern, Joshua Garbison entered outpatient treatment at Burrell Phoenix Clinic on December 12th, 25. Joshua's worked hard on understanding the addictive cycle, learning tools necessary to sustain recovery, which is why he has successfully completed treatment as of December 12th, 25. It is recommended that Joshua continue to engage in the next level of care, attending outpatient services, 12-step meetings, and individual counseling sessions as discussed in his continuing care plan. So, it does say that they're recommending you do a continuing care plan, but the one 4 days before basically says you've got several to do, and 12 to 15, and it's recommended that you complete this SATOP program. So I don't know, maybe he's meaning the same thing, but it looks, he didn't say in the December 8th that you were completed.
It sounds like he transposed the date of the letter into the date of enrollment. I noticed that too. He says he enrolled on the day that the letter's dated.
Yeah. Yeah, that's true. December 12th, which is the same day. That's when he says he's entered outpatient treatment services.
There's one that's in there.
The prior letter said May 30th.
That showed that was in there.
So what's the state's position on this?
Well, Your Honor, I was interested to make sure that, because it's in another state, we never heard of it before, that it was a legitimate operation. And if the internet is any indication, this Burrell Behavioral Health has locations all over Missouri. So it looks like a substantial organization. As far as what is written in that report, it looks like he is attending to his treatment. And I didn't really, I was kind of caught by the same thing about the date being the same, the December 12th thing. We just want to make sure that he's going to be okay from here forward, and he's got a lot riding on it because of his CDL, and we don't want to cause him any more problems. And obviously, this is a second offense, so he has the potential of going to jail. So I don't know whether a more thorough report or maybe a Zoom appearance by his counselor or something like that might be beneficial.
What's your understanding, Mr. Garbison? Are you still taking classes, or what's your understanding?
I was under the impression through them that I had the 50 hours, 20 of group education, 10 individual. I think I went over all of those just based on scheduling and off the attendance sheet. I know for sure individually I did. I did. You mentioned Zoom conferences. That's the majority of how I did have communication individually. One-on-one was with Zoom. My entire outlook on the way I was going to do that was get all my individuals done through Zoom that were scheduled, and then I could go in outpatient Monday through Friday, take 2 weeks, 3 weeks off, take vacation, and do all-day sessions outpatient that way. And that would be how the attendance record also shows.
Do you have your CDLs back now, or are you still working on that?
I do not have a license. I've got the temporary one that you guys honored here. I've been trying to get a temporary restricted driver's license in Missouri. I went ahead and did SR22 insurance with Interlock. However, with you guys having me suspended here in the state of Ohio, I cannot even get a temporary one in Missouri.
And Your Honor, I think the issue with that was, your judgment entries, the court's judgment entries would say that up to a certain amount. I think that they're taking, Missouri would not, they wouldn't listen to the explanation. I would say Mr. Garbison has expended an incredible amount of financial resources trying to do this. He was, honestly, I think he was being gouged by a California company at first. I forget what their name was, and he went to another one. I know at one point when I was speaking to, he was in the very remote area around Wisconsin and Minnesota border where he was driving over an hour one way just to go to AA meetings.
Yes.
So I think this has been and now he's been, I believe he paid for all or most of this out of pocket.
Yes.
And then, Your Honor, driving here today, I know he's obligated, but that's more than what most people.
Okay, well, here's what I would propose to do, and if you are clean, I think it's a pretty good deal. Go take a urine screen. If you're totally clean, your case is completed.
Okay.
Want to do that?
Sure.
Okay, go to the urine screen. And I'll see what the results are.
I can release copies of those back.
State of Ohio versus Michael DeMint, the second. Case number CRB 25284, CRB 091323, CRB 09948, CRB 04127, CRB 04402. Set for expungement.
Commissioner Gray, Mr. Field signed the next order. Mr. Lee, you need to sign as well.
Okay, your entries are approved. You might want to take some special care about how these get, the clerk is out, already out for a while, so I take some, yes, hear yourself to see how those get filed and distributed.
Will do. State of Ohio versus Candace Ely, case number CRB 23133. It's also set for expungement, Your Honor.
Your Honor, can I just say one thing, Your Honor?
Yeah.
Mr. Davis, at CRA 2613, I asked the jail to know if he could be brought here Friday.
Okay.
Is that something that we could do?
Yeah. Well, usually when we do that, we have them bring everybody.
Okay. Yeah. Thank you, Your Honor.
It's easier for court. And I think we're the only court that does teleconferences, so.
Yeah, I think so. I think Iron Mini does sometimes on Mondays.
Do we have an entry on this one, Mr. Morphy?
No, Judge, I had to prepare one. I thought we did. I'll bring it with me Friday.
Okay, submit it to Mr. Hill if he agrees with it, then I'll approve it.
Thank you, Otis.
State of Ohio versus Timothy Porter, case number CRB 25369, CRB 17501, CRB 14573.
That's, I think I've already signed.
Yes, sir.
Okay, so I've already approved the entries.
Thank you.
It's submitted, it's been approved.
State of Ohio versus John Davis, case number TRD 252480, A and B.
Okay, this is set for an arraignment. You're John Davis.
Yes, sir.
You received a copy of the charges?
No, sir.
This is an older case, September 29th, 2025. It's alleged that at 6:27 p.m., Fayette Township, You're driving a vehicle without a driver's license, that's an unclassified misdemeanor, maximum penalty is 500 hours community service, $1,000 fine, and not wearing a safety belt, that's a mandatory $30 fine if you're found guilty. You understand the two charges?
Yes, sir.
How do you plead to these?
Not guilty.
Okay? I'll just set it for a trial back in the traffic court, which is where it should have been. To begin with, it looks like you failed to appear for your initial arraignment.
That's what I was about to say, Your Honor, was that I guess the paperwork or something that got messed up, and because I had been in front of you even after all that. December 1st, I was in front of you and all that, but it said that I was supposed to appear on October 14th.
Correct.
And then a warrant got issued December 15th.
No, a capias was issued on October the 14th, the day you failed to appear.
That's just what I just found out, and I've been in front of you December 1st and everything else.
Well, the capias actually goes back to the OSP, so if they didn't check it,
And
so.
that woman up front, I went and asked her, she said the warrant was issued December 15th. I'm just going off what she said, sir.
There's no entry for December 1st in your appearance.
Okay. It is marked on the file, bench warrant issued for failure to appear arraignment. That's wrong, because if you fail to appear for an OSP citation, we don't issue a bench warrant, we issue a capias back to the OSP.
I have no idea.
Did they ever contact you? They should have contacted you.
No, sir.
Okay, since you want a trial, I'm just gonna put you back on traffic court. So this is not a jailable offense.
Yeah, I don't.
So I'll set it for a trial. What's the dates in,
The 13th, which is next Tuesday.
let's go to the next one, the 27th?
Yes.
Okay, so your case is set for trial January 27th at 4 p.m. right here in this court. It'll be in the traffic court.
You said the 27th?
Yes, sir.
Thank you, sir.
You're welcome. So the prosecutor will need to be made aware of that so they can subpoena the correct witnesses. Mr. Hill?
I'm sorry, John.
I just set a case for traffic court on the 27th of January, 4 o'clock.
Okay.
You said 1 o'clock, sir?
4.
4 o'clock?
4 o'clock on January 27th. He had failed to appear before, that's why he came in here, he found, and it's a non-billable case, so I'm going to put it back on traffic court.
Thank you, Your Honor.
You are.
State of Ohio recalls Kaylee Bennett, case number TRD 221604A and B, TRC 22170 A, B, C, and D, and others. We had called her earlier in the day. She wasn't here.
Your Honor, Mr. Smith said something about this case. I don't
Said
recall.
that she had called and was having trouble getting here, so I delayed it. She's still not here, so she's got 7 days to appear before warrant issues. Then we got a trial.
Yes. A recall from Mr. Robertson and the other count.
Okay, let's go ahead with that.
State of Ohio versus Alan Kennard, case number CRC 252731A and B, CRB 25686.
Okay, this is set for trial today. Mr. Warford, counsel for the defendant.
My witness is out here.
Okay. Mr. Hill is getting his witnesses.
Right there, any questions?
Brian, can I have both case numbers again?
25686 and 252731 A and B. Those are the case numbers. So, Mr. Morford, you ready to proceed?
Yes, Your Honor.
State's ready to proceed?
Yes, Your Honor.
Thank you. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
May you sit.
Sir, state your name,
Landon Hutchinson.
and where are you employed?
I work for the Thalia Police Department, South Carolina Police Department.
What's your rank there?
I'm a sergeant at the Thalia Police Department.
Were you on duty in Athalia on October the 10th, 2025, at about 7 o'clock in the evening? And at that time, did you make a traffic stop involving Alan, is it Kennard or Kennard?
It's Kennard.
Alan Kennard?
Yes, sir, I did.
Were you in the village of Athalia at that time?
Yes, sir, I was.
Was that on State Route 7?
Yes.
And do you recognize Alan Kennard in the courtroom today? If
Yes.
so, can you point to it?
Yes, he's right there.
Virtual shade pointed.
What caused you to stop him?
I had clocked him with my handheld radar gun at 47 miles per hour and 35 miles per hour zone.
How fast again? I'm sorry.
47 and a 35.
Now, after you had him stopped, did you have personal contact with Mr. Kennard?
Yes, I did. He was my driver.
He was sitting in the driver's seat?
Yes, sir.
Did he have any passengers in the car with him?
Yes.
Who was in the car with him?
There was another adult older male in the front passenger seat, and then back behind him was a younger girl, little girl, looked about anywhere from about 5 to 7.
As you were speaking with Mr. Kennard, did you notice something in the vehicle that would cause you to begin to have suspicion about maybe drug activity?
Yes, I did.
What was it?
So it's kind of like a little rubber container. From working previous drug cases, I've seen them before, and I have seen drugs being kept inside that, and that it was like a red and yellow, and it was sitting in the center console, or right in the middle.
Does it open in half or something like that?
Yes, sir, it does.
It looks like a little bit like one of those plastic Easter eggs.
Yeah, like a little rubber, little container.
Did you ask to see that?
Yes, I
device? Did you look at it?
Yes, I did.
And what did you discover when you looked at that?
Yes, I discovered it was a white powder residue, and I was told it was a toy that belonged to the little girl.
Was that on the inside of this thing?
Yes, it was on the inside.
Did you suspect that it was drugs?
Yes.
Now, based on what you had seen so far, did you have Mr. Kennard get out of the vehicle?
Yes, I did.
Did you ask him what the white substance was?
Yes.
What did he tell you?
They identified it as, I believe, crack. It was identified as crack.
Okay. When you were interacting with Mr. Kennard face to face, did you notice anything about his person or his behavior that would indicate that he might be impaired?
Yes, just slurred speech, eyes were dilated. And then after, I had got an admission of them using crack before stopping them, several hours before stopping them.
And based on everything you had at that point, did you determine that you would want to conduct field sobriety tests?
Yes.
And did he agree to submit to field sobriety tests?
No, I asked him if he wanted to, he stated no.
That time, did you place Mr. Kennard under arrest for OVI?
Yes, I did. I believe I did detain him.
Now, there was a child in the car.
Yes.
And what happened to that child?
So that was Mr. Kennard's daughter. She was very, very upset with the situation. I had to talk her to calm down because she was bawling her eyes out. I told her Daddy's okay, Daddy's right here, and I tried to let him stay by the car so he can get her to calm down. Just her presence, with his presence being there to help her, comfort her. And then I was able, once I got everything, I finished my investigation. I was able to contact, I believe, his wife or girlfriend or whatever, whomever.
The mother of the child?
The mother of the child, correct. And she was able to come and pick up, because he was released, he was able to come and pick up her, the daughter, and him, Mr. Kennard.
Based on what you, everything that you observed from the time that you saw Mr. Kennard driving up to when you made this determination that maybe he was impaired, did you charge him with OVI?
Yes.
And also because of your belief that he was impaired, did you charge him with child endangering?
Yes.
Now, was a passenger in the car?
Yes, there was.
Do you remember his name?
It was William something.
Was it William Smith?
William Smith, yes.
Now, did you have some interaction with him as well?
Yes, I did.
What happened there?
As I had Mr. Kennard get out the vehicle, once I had him get out, I kind of still sort of watched the vehicle, so there's no movement, or if they're not making sure they're not tucking anything on me. And as we had got him out, I was speaking with him. I see Mr. William doing a lot of movement, so I get up there and his body's kind of turned on me to the side, and he looks like he's shoving something down in the seat. I don't know if it was a gun, a knife, or whatnot, so that's whenever I did pull my taser out. I said, "Hey man, show me your hand if you got something." It ended up being a meth bubble, a crack pipe that they used to smoke out of, and now he did take ownership of that.
Now, did it turn out that he had a warrant for his arrest?
Yes, he had a warrant for his arrest.
And was he taken to Johns County Jail?
Yes, he was.
Were you wearing a body cam during all this?
Yes, I was.
Was it recording?
Yes, it was.
And did you turn a copy over to us to be used today?
Yes.
Do you have a chance to watch it since this?
Yes, I have watched it since then.
The audio is working on this. I know the audio works. Can I listen to it? It's always something. There are maybe have to have John come in here and help us.
We asked John to come in and see if he can do something with it to get the audio to work.
Sorry, Ron, didn't hear you.
It's okay, the video is working, but we're not getting any audio.
Okay.
That's in my headphones. Yeah. Speakers. You're welcome.
Hello, how you doing? Hey, so we're not stopping there, I got that 47.
I was coming from the flea market.
How come we went so fast there?
I didn't realize I was coming out. I had to walk in the middle of the street here.
I got it back there, when it was still 35, that's at 47. You have a license on you, sir? Okay. How much registration insurance? Give me it. Give me it now. Give me it now. You just tossed it. Give me it now. You see what? What did you show underneath there? Okay, let's keep that. No problem. I'll take that. No, you're not. No, you're not going to do that. I'm not okay, sweetheart. Sweetheart, listen. Hear me out. Sweetheart, hear me out. You're okay. Daddy's not going to chill. I'm just wanting to talk to him, okay? Hey, sweetheart, listen to me. Calm down, okay? You're okay. There's no bossing about that. You just shut in the seat. Do you want to go to jail? Don't play stupid with me, okay? Give me the dope. There's dope.
There's no doubt, sir.
Give me the dope when you go to jail. Just go underneath the seat. Keep your hand out here, okay? I'm not going to play that stupid stuff, especially with your girls party. Put your hands behind your back. Step back here. Step right back to the booth. No, not right now. I'll see you there. So, if you want to work. 37, 968, 0, X-ray. 968, 0, X-ray. We'll be stopped outside. I'll take you to go too, I don't care. Okay, you got a little bit of go in the car. You got to go to the bank. I'll text it right now if you don't get your hand up. There's no in that car, okay? Where did it go? When was the last time you used it? Be honest with me. Probably about an hour ago? How long ago? A couple hours? 45 hours enough?
I didn't even know, I don't do math.
Well, what is it? I'll test it. Turn it on?
Yeah, that's correct.
Try it? Okay. What's that? Well, I don't care if you got the, that don't mean anything. You got to get the daughter in the car. Get it? No, you obviously don't know. That's bullshit. You okay, sweetie? Hey, you're okay. Daddy's right here, okay? Hey, listen to me. Nothing's gonna happen, okay? Huh? He's in the back of my car. He's talking to me, okay? Just hang tight, okay? Alright, you're fine, okay? I promise you, nothing, you're okay, Daddy's sitting right here just talking to me, okay? Alright, well, just hang tight, okay? Nothing's gonna happen to you or Daddy.
Yeah, 433, 47.
You're not, but you're not, you can't believe that. You're not on the rest of this attorney, okay? I want you to sit down with me, okay? Yeah. Not around the bubble real quick. Well, we got that, we have cracked residue in the thing. I just said, well, and test it right now, and pop the test. Huh? No, that's not what it is. You're ready? Huh? The baby's right there. Right there. The little tiny dog? Maybe. Give me 1 second, I'm on the floor. Huh? Who? Cam? Okay. Huh? You can sit over there and look real quick. I'm just talking to me. No. He's just talking to me real quick. Where's your mom at? I don't know that, okay? You go to school? Yeah. You leave my school for a second? He said this is cracking. Who's taking ownership of that? Because I got enough to scrape up. Okay, it's either that or you. Huh? It's 70% possible, it's either that. If you don't take ownership of it, it's going to be yours, because you're the owner of the car. Okay, then you take it out for it. I got child danger in that, felon child danger in that, and possession of crack. Okay, felon possession of crack.
Talk to him and see if he'll take it.
Which one do you feel so you don't have to, that doesn't mean I'm going to take you to jail to say no, okay? You don't have to, I just have to offer to you, okay? We openly admitted to using it about 4 hours ago, okay? So you can say no, but you don't have, that doesn't mean I'm taking you to jail, I just have to offer to you. Do you want to do it? You don't have to, I just have to offer, yes or no? You don't have to, is what I'm saying, I just have to offer to you.
I'm just saying, I'm happy and
Okay, well, I'll ask you, do you want to do anything to about it? You don't have to, I just have to offer, doesn't mean I'm taking you to jail.
I don't want to go to jail,
So, no, you don't want to, that's fine, you're not, okay. You don't want to?
I don't want to go to jail.
Oh, I'm asking you, it's either yes or no, you want to do, you don't have to, okay. You don't want to? Okay. Where's the Did you already use it? Well, I put it in there.
I picked it up and put it to the fair.
Let me just tell me. So don't lie to me. But I'm not taking you to jail, dude. I'm not even playing with you. Okay? I'm not doing that wrong shit. I just talked to me. Okay? So when I'm gonna do this stuff? Okay, where'd you get it from?
Pop come from down up there to the fairgrounds. Picked up that little thing here, going down the lake, just didn't do it. That's true.
So you're really going, I'm gonna sit there and look around on the shoulder for everything I do.
And you don't really know anything happened from my.
So it's yours. Because if that's the case, I'm gonna charge you for the child endangerment, felony child endangerment and possession of crack. Okay?
Yes, sir.
Okay? You got ID on that? You don't have, step out there real quick. And I don't know what you're thinking, having that shit recorded with the kid or a long time. Why do you think that shit right?
I'm on there for whatever.
Okay.
So I don't do that.
But why? That makes sense. If you see a crack pipe on the front, why the hell you don't feel
Yeah,
that?
that's true.
How many times I've heard that?
I'm being honest with you. It's very much, I think.
Where's your idea?
I don't have one. Everything I've got sold, I'm never gonna.
Yeah, did you talk about education at all?
Report card in there. When it stops there.
What's your first name? W-I-L-L-I-N, middle initial?
Yes.
Last name?
Yeah.
What's your, date of birth?
12/64.
12 what?
12/64.
12/64?
Yes.
What's your social?
236.
236, 13?
711.
7 what?
911.
I mean, you might understand where I'm coming from, about $80 and always a toy. That's not a toy. Yeah, that's what you put your budget in. That's not a toy.
That's what somebody put in their bed.
But people put their okay, and that's not true. It's not trash in it. How's that a toy? Was she playing with the crack? That's what you said about the camera?
Cracking there and things.
He said he's cracking there. So obviously, you don't know what it is. He said it's a toy, and it sounded like she was playing with it. Was she playing with it?
No.
You said it was her toy?
That's what I figured, well, it's in console.
But what do you think about that then?
I don't know. It's in console.
This is what I do. This is what I do. I like working roads, okay? And this really ain't shit, it ain't nothing. You know, this little bit of dope, you guys are years, I understand that. But don't sit here and lie to me. Honestly, goes along with me. If you sit here and be straight up honest with me, I wish you done today, but don't sit here and lie to me about
I do
it.
that, sir. All day. I do that. I just got out of there 2 weeks ago.
Well,
Conspiracy committed LA, driving 2 other guys around in the car. Big old.
you got a guy on?
Yes, sir.
There has to be one. I right here in a second. Who are you then? Okay, so you're taking ownership of the crack pipe and the rubber, this stuff with the crack in it, right? Okay. Alright. Hold on, sis, we'll be right with you, okay? So that, where's all the pipe from? You know? Okay, where do you get the rubber, because you knew it was crack, you identified the substance as crack. Okay, that's on camera, so you can't say that you didn't know what it was.
That's where we're getting to.
Okay. Okay. Where did you get it? Where'd y'all get it at? It might be good, I'm not saying. You bought it over in Huntington? Okay. Y'all both smoked a little bit of it? Okay. You said about, you told me 4 hours ago. Okay. But you smoked? I had to take a puff of it? Okay. Okay. And take a little bit of a car, man. You're a dude, come on now. That's not good work, dude. We decided back then, now we grabbed it around 7, remember what we did at that thing on that? In July? That was that calls to just in the right, dude. Who does she live with? I'm on the video. What's your wife's number? Area board 690 what? 3392. And what's you got ID on the car? Yeah. Okay. And what's your wife's name? Holly. H-O-L-L-I-E. And what's her last name? F-I. And you guys are married? Yeah. Okay, so that's, y'all just have that one daughter, or? Is that daughter Holly, with Holly? Okay.
Sure, I'll be honest with you, I'm not messed up or anything,
it's slow speed, man, I never see videos. Well, what do you not see that? Listen, I work completely other, man, crap, you gotta look at it, listen, I really need to do, that's what it is, I'm not serious. He said, oh, that's her fault. So you're not telling me she was one of that then, right? He said it was her fault, I don't care, did he not? And then that's why all that film is showing me, the crap out I'm gonna see, I'm not done, that's why I walk back here. Yeah, you know what that is, that's criminal evidence, that's a felony period. So you got both committed felonies, you get what I'm saying? Where do you get at? Where's the other guy? Now hear me out, I'm gonna put the police over the car, I'm gonna find you in another. Not if I can there another. That talking about. How long will you work? How long have you been going? Are you retired already? So you got what? 25 years, 20 years?
I did almost 20 years. I got on disability. I PTSD.
Oh, okay.
That's why I'm nervous. I'm getting stressed.
Okay. Well, you see where I'm coming from though, right? You know, with my situation, honestly. I mean, not trying to be an asshole, but I'm just being honest. You know, you got, I had a big vegetable girl before around. You just got to think better than that, dude. You know, she went and picked it up and, you know, she's on the floor and then something happened to her. You probably wouldn't know, you know. She seems sweet, you know, she cares about, she worries about you, dude. You know what I mean? That's not fair to her. I mean, whatever you do without her, that's one thing. But don't put her at risk. She's always good, you know? So, I'm going to room call. I'm going to sit like that here. Just have her take a call and just try to keep her calm down a little bit. I'm going to make a phone call quick to my supervisor, like that, and I'm going to see what he thinks I should do, okay? said on over there, and you need to quit lying. I don't like lying. Hate being honest with me, and you're just bullcrapping me. Probably got a warrant, don't you? Yeah, you do. Yeah, you do. Look, you got a warrant, I'm looking at it right now. You got a warrant here, yes you do. Yes you do. No. 23613-7910, date of birth, 12/12/1964. You got a failure to give warrant. Morris County Sheriff's Office. Well, you did, you got a warrant, I'm looking at it right now.
Sergeant, was that a fair and accurate representation of what your interaction was with Mr. Kennard and the other fellow?
Yes. Yes.
And Your Honor, I'm going to ask that you mark the state exhibit 1, and I'm going to ask it to be admitted.
Any objection?
No, Your Honor.
Admitted.
You need it, Butch? You going to play any of it?
No.
Did you cite Mr. Kennard for speed also, 47 and 35?
Yes.
That's all I have, Your Honor.
Cross.
Did you calibrate your radar that day?
It self-calibrates itself, it won't work properly or even turn on if it.
Self-calibrate?
It's a self-calibration, yes.
The only indicator you had that, the physical indicator of the defendant, they might be impaired was dilated eyes, is that correct?
Yes, and slurred speech.
He didn't have any problem finding his documents for you, did he?
I believe I grabbed his ID out of the car.
He had his ID right there ready for you when you approached, didn't he?
Yeah, he didn't have a problem handing that to me.
And the other passenger claimed ownership of the rubber ball
Yes,
and the crack pipe.
yes.
You didn't do any tests on the contents of the rubber ball, did you?
No, I didn't. They identified it as crack.
The only traffic citation you wrote him for was speed, Sergeant?
Yes.
You didn't write him for brakes control or anything like that?
I cited him for ODI refusal.
Okay. What indicators of OVI did you have other than speed?
Other than speed, traffic, other than speed, you said?
Yes.
I mean, I didn't have like more claims or nothing. I just had the speed for the reason I stopped him, and then the slurred speech and the dilated eyes.
His speech wasn't slurred, was it?
It sounded slurred to me, yes.
No accident was involved, was there?
No, sir.
He didn't undergo urinalysis?
No, sir.
No blood draw?
No, sir.
And he decided not to do the field sobriety test that you offered him?
Correct.
He didn't go left to center, did he?
No.
Didn't go off the right-hand side of the roadway, did he?
No, sir.
Over the fog line?
No, sir.
That's all I have, Your Honor.
Redirect.
Sergeant, you cited him for child endangering.
Yes.
Did the fact that he admitted having used crack cocaine that day and driving a vehicle with his child in the car have anything to do with charging him with that?
Yes.
And the fact that there were drugs, that he admitted that it was residue of crack cocaine in the car, with his child in the car, they're driving the car, did that have anything to do with charging him with child endangerment? And that and the dilated eyes and the slurred speech, did that also contribute, along with those other things, with your decision to charge him with OVI?
Yes, sir.
That's all I have, Your Honor.
Cross. Anything else, Mr. Moore?
No, Judge, no, thank you.
You may step down, sir. Thank you.
Thank you.
We rest, Your Honor.
Any evidence from the defendant?
1 second, Your Honor.
No, it's clearly right there. I mean, I can. No.
No, Your Honor, we're not calling witnesses.
All right. Well, based on the evidence submitted then, I'm going to make a finding of guilty on all the charges. Is there a recommendation on sentencing?
Your Honor, if it please the court, I think it was reckless of Mr. Kennard to have his child in the car with him, with that fellow doing what they were doing that day. And I honestly think that that, in my mind, is more serious than the OVI. Obviously, they're interlinked, but I just think that he's failed to understand the seriousness of this. And I think that there needs to be repercussions for it. Now, I also know from watching the video that he's a veteran and he served a long time apparently, and I respect that. And I hope that the court, if the court finds it appropriate to order him to do treatment, that the VA can help him. But I think under the circumstances, there needs to be some jail time imposed, in addition to the other mandatory sanctions.
He is a veteran, Judge.
Disabled.
And I recognize he's a veteran.
Mr. Morford, anything you wish to say?
No, Judge, thank you.
Mr. Kennard, anything you wish to say to the court before your sentence?
Yes. I first want to say I'm embarrassed, Your Honor. I would never endanger my little girl. She means the world to me. I didn't even know that that stuff was even in the car. I wouldn't have just pulled, I wouldn't have just was going to hand him my license with something in the middle of the console if I knew there was something in it. I wouldn't do that. I didn't even know it was there. When he had asked me if I had smoked it, I thought, it sounded like me, you know, like, when's the last time he smoked it? But I thought in my head was like, when's the last time he smoked it? I wasn't trying to admit guilt of smoking it 4 or 5 hours ago. I was trying to be honest with the officer, not give him a hard time. I pulled over, I did everything he asked. I do know it's serious. I'm very aware of that. This is the first time I've ever been in the court, never been in jail, never been arrested. It's me going around the wrong people. The man stole off of me, stole stuff off of me just recently. I've lost that. I quit, I just stopped communicating altogether. He hasn't even showed up for court. He hasn't showed up for anything. He didn't do nothing at all. And he's put me in this position that it wouldn't even been, that day we was going from the flea market, because I do flea market stuff. And we had went through the town already once. And we was coming back home from setting up at the flea market. I do flea markets. I started early in the morning, so I was kind of tired. I was wore out from working, doing that stuff. And when he had pulled me over, I didn't know why, because I was watching my speed through the town, because I seen him pull over multiple cars that day. He pulled over probably, we went through the town, he had someone pulled over. So after I was going through the town, getting ready to hit 55, he pulled me over past the 55-mile-an-hour sign. So I don't know how he thinks that I was speeding or I wasn't swerving. My speech wasn't slurred like he said it was. I was not on anything. I just wanted the situation over, Your Honor. I was worried about my daughter. She was screaming at me the whole time, "You going to jail?" Watching that video is the worst thing ever. Worst day. It was a mistake. Should have never had that man in my car. Should have never had anything to do with that. I don't want to go to jail. If it's treatment, I'll take a drug test right now and show you that I'm not on any drugs. I just don't do drugs. I don't smoke. I don't drink.
Well, I think that's a good idea that you did a urine screen today before I actually sentence you. So I'm going to order you to go do one, then get the results, and you'll come back and I'll sentence you then. So that'll make a difference if, to me, as to how I handle it if you are clean now. So go do a urine screen. What else we got?
We're waiting on the urine screen results from Mr. Garbison. I haven't been given those yet, but we're waiting on that.
He has not done it yet, Your Honor.
Okay, court will be in recess.
Always exciting in prom.
No, yeah.
Have a good week, bud.
You too.
Get a
This came in on second, here, Robertson. Our back people down, didn't have a sign. Yeah, this is from the second. Probably.
Lawrence County Municipal Court's now back in session. State of Ohio versus Allen Canard.
Okay, we need the lawyers in here. Yeah, they seen the...
Yes, Your Honor, they've seen
Yes. Okay, well, we got a problem. Maybe more so than you want to admit, Mr. Kennard, obviously, so.
Your Honor, I don't do fentanyl. I don't
You
do, I
tested
don't,
positive for it, so that's what I'm going
I
off
take
of.
medication. I take anxiety medication.
All right, well, here's what I'm going to do on your, we'll start with the ODI. I'll give you a $400 fine on that. That's close to the minimum, mostly because you're a veteran. I'll charge you the court costs, $125. I'll give you a 6-month license suspension. And that started the day of the incident, so October 10th. You've been under a suspension since then. Uh, 20 days in jail. I'm going to suspend all 20, but only on the condition, I'll get some conditions for you. One is you got to go get treated at the Veterans Administration. I've already sent your information to them. So they're going to be looking for you. I'll probably call you. Let me see if she responded. She's pretty good about responding. Okay, she says he's in our system. I'll call him. Thank you. So she's going to get in touch with Amanda Rayburn. She's going to set you up.
Okay.
They got her, that's the one in Spring Valley. Are you familiar with it?
Yeah, I used to work there.
Okay.
I know her.
Really good program there, and they work with the court very well. So they're going to let me know what you're doing and what you're not doing. So let's get this taken care of and get off the drugs, whatever it is. You're denying fentanyl. Fentanyl, well, here's the thing about fentanyl. If you take anything off the street now, it could have fentanyl in it. Anything. Even if somebody says, here, take one of Grandma's hydrocodones, you got a really bad headache, it could be fentanyl. It may not be a hydrocodone. You can't take anything that's not prescribed for you, that you don't know yourself came from the pharmacy. And that includes weed. I think we're setting ourselves up for a big problem with THC, but that's another rant I could go on. Not off the street, but it's got, the place there in Proctorville, that dispensary, they're gonna have to rent one of the old Walmarts eventually. It's amazing how many cars are there.
Your Honor, can I get privileged to drive? Because I do Spark and also,
Yeah, I'll let you drive.
and also I pick my daughter up from school too.
You can drive for work, to come to community service. I'm going to require you to do 5 days community service, to go to the VA, to go to counseling, which is the same thing. That's where you're going to go to counseling, and any court sessions you have.
Okay.
Your Honor, what would you like to do for a review hearing date?
Pretty soon. So let's make it March 2nd will be your first review hearing, first Monday in March. And I'll get a report from the VA by then as to what you're doing and not doing. Okay.
That'll be at 9, Your Honor?
That'll be at 9. Then he had child endangerment. On that one, I'm going to give you 30 days in jail, suspend it all, but it's hanging over your head and can fall on you if you're not, if you're not getting clean.
I understand.
And don't put this little girl. Have you ever heard of adverse childhood experiences? It's called ACEs, is what they call it. Seeing your dad arrested is an adverse childhood experience. Having a parent with a substance use problem is an adverse childhood experience. The more ACEs a kid has, the more the chances are they're going to abuse substances down the road.
I understand.
And we don't want that, do we?
Mm-mm.
Okay, so let's get this cleaned up. Be the father that you need to be to this little girl. Okay, so on the child endangerment, I'm going to impose a $300 fine. No court costs because it all happened at the same time. 30 days in jail, all suspended. And you already put the counseling with VA on the other, right? So.
I did.
Okay. Same review time, March 2nd. And then the speeding, $20 fine on speeding. It's not a big deal. It's what started everything. Okay, he'll need to go meet with Mr. Major. And then after that, you're free to go. Be back here March the 2nd for your review hearing. And do what the VA sets up for you. They have a great program. You follow what they tell you to do, we're going to get this problem taken care of.
Okay.
But I'm not giving you jail. He wanted jail, and I don't blame him. But I'm holding it over your head, so if you screw up, you can go to the jailhouse.
I won't.
Okay, don't screw up.
I'll get done.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Joshua Garbison, case number TRC 24746, A and B. This was originally set for jail today.
Okay, cool. All right, he's positive for alcohol, so that's not good. And did Mr. Holt leave, or?
Yes.
Okay. All right, so what I'm going to do, I'm not completing you then. I want you to continue with the treatment and do all the things that they set forth.
Okay.
And then we'll set another hearing. I'll let you appear this one by teleconference. I'm not ordering you to jail now, but it's still a possibility.
Okay.
Here's the thing you need to understand, and I want us, you need to knock my socks off with how much you've done to avoid this. Do you understand that I'm disobeying the legislature in the state of Ohio?
Yes, sir.
They made a law. They don't trust us judges to do what they think is right. So they made a law on these second offense ODIs. I'm supposed to give you a minimum of 10 days in jail.
Yes, sir.
That hasn't happened yet. Now, the prosecutor was on board with it because we'd rather see you get clean and stay clean.
Yes, sir.
But you haven't wowed me yet on what you're doing. So I need to be wowed if you don't want to go to jail.
Yes, sir.
And I understand, you know, you've had a CDL, so you've been driving some sort of bigger truck on the road. That's a danger to all of us. I mean, that's a big responsibility.
Yes, sir.
And I don't feel comfortable with you going back doing that if you're not going to really commit that this is never, ever going to happen again.
Yes, sir.
Okay?
May I ask a question?
Yes, sir.
What would you, I'm assuming, I'm good, you said teleconference, I'm good to go back to Missouri.
Yes.
What would you like to see from that treatment program?
More detailed reports. I mean, it's pretty vague what they're
Right, well,
telling
and I apologize with that. He just took over and I happened to be his first graduate or completion or whatever.
And here's the other thing I want you to do. Go back and tell them, the judge made me do a screen and I tested positive for alcohol. I'm assuming you're not supposed to be testing positive for alcohol now.
With him, I was, as long as I was in the program, I was not. We did do testing there. Went out and watched football at the bar last night and had a beer. Shouldn't have done it. I get it, especially while I'm here. I was just more detail about treatment and progress.
Tell them I got to be convinced this is never, ever going to happen
Yes, sir.
again. And tell me what they're doing to make sure that's the case.
Yes, sir.
Let's set your next hearing. Does it matter what day of the week it is?
Whatever works.
Okay.
I will, I'll go back to my weekly meetings with him, hopefully. Typically, I'm off on Fridays.
Okay, I'll set it for Friday. That would be better for your...
I don't mind, I prefer Monday.
You prefer Monday?
Because I would actually go in and do group meetings all day Fridays if I am home.
Let's set it then for the 23rd of February. That's
23rd?
That's 23rd, that's a Monday. February 23rd, it'll be at 9 o'clock, and you can get on teleconference.
Okay. Thank you.
Okay. Have a safe trip back.
What was that?
Have a safe trip back. You're going back to Missouri, right?
I have a suggestion too, that if your counselor could be on the Zoom call too.
Yeah, that would be great.
And that way you can really fill it in.
And I did find their website. If you, it doesn't matter now, but if you would like to see the credentials on that.
You looked it up.
Okay.
You already
From my end, I have a hard time here, so it sounded like you couldn't find it.
No, I found it.
Okay.
So,
okay.
I'll see if I can get him now on that and we'll go that way.
all right.
Thank you.
Thank you.
Thanks, guys.
Okay, court's adjourned, finally.
Yep. I'll write it in my book out there.
Okay, gotcha.
Good job, Mr. Eli.
Thank you. Long day.